Delivery of order, item number 1.
For reasons mentioned in the order, the prayer for bail is dismissed, rejected.
Most of it. Wait, please.
Yes.
My lord, both sides, my lord, pray, my lord, that the item, my lord, 21. My lord, this is second appeal of 2012. It may be fixed on next Thursday, my lord, 25th as a first item of the hearing. Today it may not reach, my lord, it is in the bottom, my lord. Very old matter, my lord. 25th as the first item of the hearing. It will not take much time, only one appointment.
Both sides are requesting. 25th of Manas. It will be convenient on
My lord,
2nd of December.
Or 27.
27th, my lord, not 25th,
27th also we have fixed
Yes.
cases. Fixed cases.
27th.
Fixed cases are there. 2nd of December would be convenient.
Second.
2nd December. Heard Mr. G. N. Sahiwala, learned senior counsel for the appellant. Also heard Mr. S. S. Datta, learned counsel for the respondent. On request of learned counsel for both the sides, let this matter be listed as a fixed item for hearing, as the first item for hearing on 2nd of December.
Obliged.
Item number 29 and 30, my lord. Those are, my lord, 2019 matters. My lord, and the first incident occurred in the year 2015. Till date, my lord,
What is your request?
my request is
19.
maybe taken at 2, my lord.
No.
Then, my lord, another date may be fixed with the direction to list the matter on the top of the.
No. Wait for your turn. Otherwise, we have to relist, reschedule the entire cause list. No.
May I please, your lordship, with regard to item number 19, my lord, with the consent of the other side, my lord, I'm praying on behalf of the respondent, my lord. I'm praying only for today, my lord. Some accommodation only for today. Actually, my lord, PK Kul, the senior advocate, was leading in the case. He is not presently.
Heard Mr. What is your name?
Endas, my lord.
Heard Mr. Endas, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondents.
Can it
Appellant,
be-
who is for the appellant? What is your name?
Endas, my lord, on behalf of Mr. P. Chaudhary.
Learned Mr. M. Das, learned counsel appearing for me on behalf of Mr. P. Chaudhary, learned counsel for the appellant, does not raise any objection to the prayer made by the counsel for the respondent. Hence, the prayer is allowed.
On 4th, my lord.
No fixed date. Registry will give the dates.
May I please, your lordship? Lordship, I'm praying for listing of one RFP for orders, lordship. Lordship, kindly next week.
Okay, next week. Okay.
Let's, lordship.
May it please your lordship. Lordship, I beg to mention item number 11, my lord. In item number 11, my lord, we'll be filing an appropriate application for withdrawal of our names from the petition, my lord. We've had no contact from the client and we have taken 2 prior dates, my lord, from this honorable court on the same occasion. Item number 11, we've taken consent from Mr. B.K. Bhagavati, my lord, for the respondents.
Heard
Miss-
heard Mr.
M.
What?
Sharma.
F.
M. Sharma, my lord.
Heard Mr. M. Sharma, learned counsel for the petitioner, who submits that since the learned counsel has lost contact with the petitioner, they intend to withdraw from the case and seeks leave of this court, seeks some time for filing appropriate application in this regard. He has submitted that he has informed about this fact to the learned counsel for the respondent who does not have any objection. The prayer is allowed. Let this matter be listed after a week on
My
a
lord,
date.
I'm
to be
grateful.
fixed.
Please, Your Lordship, I beg to mention item number 7 with due consent of the other side, Lordship.
No
We-
consent, I was informed, my lord, two things, a date may be fixed, I most humbly pray, and also, my lord, there's an order of this honorable court dated 24th of September, that they have to argue for, to escape the allegation of fraud. My lord, for that, the rent controllers ordered, my lord, that appears at pages 215 to 218 of your lordship's brief. My lord, Miss NJ case number 423 of 2009, if that may please be called for by this honorable court. A date may be fixed, my lord, and my lord, that order may be called. My lord, in any event, I'll be able to argue.
Which order?
My lord, the Miss NJ case, the order of this honorable court dated 24th of September.
Yes, what is your
This year.
prayer?
Yeah, well, I pray that the miscellaneous NJ case, the rent deposit cases which were dismissed for default, my lord, the rent controller in Dibrugarh, Municip number 1, my lord, if that may please be called for.
Is there any application for the same?
There is no application, but my lord, they say that they have deposited rent. They have not denied that that
No,
particular
not at
document
the
which we have
mentioned stage.
witnessed.
For that, we have to go into the records.
They have filed affidavit in opposition to which we have replied and we have filed it on
Today,
yesterday.
your mention is about adjournment prayer only.
Yes, Lordship. I am for the petitioner, Lordship.
Okay, we are fixing a date.
Lordship.
Heard Miss S. Todi, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. No,
File affidavit in reply yesterday. That is not on record. On that ground, I'm seeking an adjournment.
seeks an adjournment as the petitioner has filed an affidavit which is not on record. Mrs. Sharma, learned counsel for the petitioner, learned counsel for the respondent. On the other hand, prays for, on the other hand, raises no objection to this said prayer. However, she prays for calling of certain NJ cases,
Appears at pages 215 of your lordship's brief.
mention about which has been made in page number
215 to 218 of your lordship's brief.
218
Pages number
15 to
215 to 218 of your lordship.
of the
Miss NJ case number 423 of 2009
snub.
from the rent controller at Dibrugarh, Municip number 1.
The considering the submissions made by learned counsel for the parties, the prayer for adjournment is only the prayer for adjournment is granted at this stage. Regarding the prayer for calling of the miscase, records of the miscase, the brief has to be gone into. Hence, a fixed date is given. When do you want?
On 9th of December, Lordship, Tuesday or 11 December.
Let this case be listed on. Any objection?
9th of December.
9th of December.
Obliged, Lordship.
Yeah, please, Lordship, this CRP will be listed on 26 in a motion matter. In earlier article that was listed, and Lordship has given a direction to file an additional affidavit. We have filed. The title suit is it fixed on 29. So one of this matter is urgency here that will be listed on 26.
Okay.
Yes, sir.
May I please, Your Lordship, my prayers for listing CRP, I for admission next week, any date, Lordship,
Next week.
next week.
May I please, Your Lordship.
Well, this, if MSC appeal will not pending since long days and the
Second week of December.
victim is a permanent disabled man.
Second week of December. Prayer for listing.
Hello?
Is it a prayer for listing?
So, my lord,
What is your prayer?
yes, my lord.
What is your prayer?
But maybe first week of December, my lord. For listing. For listing.
Second week of December.
Wait, I beg to mention item number 24 of today's list. The compromise talk is going on between the parties. And possibly it will be done in few weeks. So matter will be taken up after 3 weeks, Lordship.
You have informed the other side.
My
I am for the respondent lordship. Actually, we got it listed by filing an early hearing application. Anyway, yesterday they have initiated a talk of compromise. My humble prayer, only a date may be fixed for hearing. If by this time this compromise is,
No, if there is a talk of compromise,
after 3 weeks, a date may be.
no, no
In
date.
both cases, it will be, if compromise is successful, then also it will be.
If compromise, you reach a compromise, then you mention for listing. We are fixing it after 3 weeks. On request, heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. SD Purkas, the learned counsel for the respondent. It is submitted at bar that a talk of compromise is going on between the parties. And there is a possibility of reaching an amicable settlement in this case. And therefore, some time is prayed for. The prayer is allowed. Let this matter be listed after 3 weeks.
May it please your lordship, with the consent of the other side, I beg to mention item number 4 for an adjournment. Your lordship, my senior is having some personal difficulty.
What is your name?
Lordship, my name is S. Das. My senior's name is SP Sharma.
Heard Mr. S. Das, learned counsel for the respondent.
Number 6.
Number 6, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the learned counsel for the petitioner regarding his prayer for an adjournment, who does not have any objection to the same.
Date may be fixed to which.
Hence the prayer is allowed. Let this, no dates.
Can it be on 4th of December?
okay.
There is identity in our part. I am for the petitioner.
Okay. Let this matter be listed on 4th of December.
May
Pass
it please your lordship. Lordship, I beg to mention for listing an IA for release of money, lordship. In MSC appeal, lordship, on Tuesday, lordship. I have filed on 6/11, lordship. Tuesday, lordship.
Okay.
Oblige your lordship.
May I please your lordship, I may pay for listing of a MSC appeal next week, lordship.
Not
hearing.
first week of this, second week of this.
May please your lordship. Lordship, I beg to mention for listing I regarding pertaining to RFA. The RFA for early hearing lordship. Subsequent development has occurred lordship. We have received a notice under section 32 of the SFACL regarding repayment of the loan lordship.
Next week,
Can be listed on Monday lordship.
next week.
May please your lordship. I beg to mention item 8 lordship. We have filed additional affidavit. I have taken consent. So matter may be fixed in next week, your lordship, any date.
Heard Mr. S. Dasgupta,
Lordship.
learned counsel for the petitioner, who submits that the petitioner has filed an additional affidavit which is not on record, and prays for calling the same on record. Let the additional affidavit be called on record, and let this matter be listed in the next week on a date to be fixed by registry. Next week.
May I please, lordship? Lordship, I have to mention one listing on VA, lordship. In this case, lordship, already co-accused got bail from this court, lordship.
BA, go to registry. Pray before registry.
The co-accused got bail.
Pray before registry.
Quickly.
Lordship, item 8 I mentioned is appearing. So a date may be fixed in the next.
No
week.
dates. Next week. Registry will fix the date.
Okay.
I will not come, my lord.
We'll see. Even if I fix, it may not come.
Then
If it does not get listed in the next week, you may mention.
lordship. Lordship.
May I please, lordship?
My lord, the petitioner, he was arrested on 5/8/2025, my lord. Today is 108 days behind the bars. He's a 59-year-old man, my lord, and having serious health issues, my lord. Apart from that, he is in the age of, my lord, attaining superannuation in his service.
Oximeter,
My lordship, notice was issued, my lord, we have taken steps, my lord.
what has happened to him?
Service completed, lordship.
My case is that, my lord,
No, we will appoint one amicus today.
lordship.
Heard Mr. M. K. Das, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served. Stop. Since no one has appeared to represent respondent number 2, this court is inclined to appoint one amicus curiae for defending the cause of respondent number 2 before in this case. Accordingly, Ms. M. K. Brown, learned counsel whose name appears in the list of amicus curiae prepared by the registry, is hereby appointed as amicus curiae in this case. The petitioner is directed to furnish the copy of bail application along with annexures within 2 days.
My lord, may I pray, my lord, because, my lord,
When will you furnish the,
today, my lord, will furnish, my lord.
within the course of the day?
My lord, may I pray for tomorrow, my lord?
No, no, no. The amicus has to go through your application and take, if necessary, take instructions from the victim
Monday, my lord,
on Monday.
deeply obliged. I'll furnish the copy.
Let this case be listed on Monday. The registry is directed to reflect the name of Miss M. K. Brown as amicus curiae in this case, in the cause list henceforth.
Lordship, in item number 18, Lordship, our name is not in the petition, Lordship, but it is wrongly reflected in the cause list, Lordship. Item number 18, Lordship. It is in hearing, Lordship. So it may be struck off, Lordship.
Select matter.
Yes, item number 18 by mistake.
Item number 18 to be the.
No, not necessary.
Okay, like
Where your name is shown.
it is in the 18, Lordship, in the last, before SC, standing council stands for department above, Lordship. PP Assam.
Okay.
But in the petition, our name is not there, Lordship. It is not we are not implemented, Lordship.
Okay, while taking up this matter, we'll strike out your.
No, I will not be, may not be present. I
No,
will
not
defend
necessary,
for Lordship.
not necessary.
Lordship, much obliged.
Wait, Your Lordship. Lordship, in a divorce case, Lordship, I filed one application for adjournment of the case, Lordship. My adjournment petition was dismissed and my right to cross-examination was closed and the case was fixed for Lordship DW. My petition is on page number 49. 49 is my adjournment application. Lordship, I am a senior engineer working at Numaligarh Refinery Limited, Golaghat. I also resident of Golaghat district. And the case is pending before the learned district judge Dhemaji. And the case was fixed on 15/9/2025 for cross-examination of the PW2. And on 14/9/2025, Honorable Prime Minister of India visited Numaligarh Refinery for inauguration of the bioethanol plant. And for this reason, I couldn't secure leave on particular because I had to move to Dhemaji one day ahead of the fixed day. Since 14/9/2024, I couldn't secure leave and I had to remain busy on 14/9/2024 for the whole day.
Where is the impugned order?
Impugned order is on page number 53. And the main order is on 54, which is the first letter.
You have failed to pay the earlier cost.
Your lordship, I have stated in pair number 13 of my petition that the cost was imposed on 6/6/2025. And on the very day, since I was a resident of Golaghat, the very day I have paid the 4,000 rupees, the cost to my engaged counsel to deposit it. And my engaged counsel intimated me it has been duly deposited. And here now he intimated me perhaps due to some reason, communication gap between the courtmaster and the honorable court. It was not reflected on the record. I have duly deposited. I have stated in pair number 13.
Your statement will not do. Order sheet shows that you have not deposited.
My only submission is a last chance may be given to cross-examine a PW2. The cross-examination of PW1.
What happened on P 1510? On 1510, what happened?
1510, since lordship, I was on that day also I prayed for adjournment of the case because that was fixed for cross-examination of DW. But I wanted to cross-examine the PW.
No, what happened on that day?
That was, the case was adjourned and fixed on tomorrow. Next date is case of 21, tomorrow for cross-examination DW. That day adjournment was given. PW2 is the brother of my wife and it's a very vital witness. I want to cross-examine him. One last chance may be given. Because the cross-examination of the PW1, my wife was held only on 11/7/2025. And next date was given 21/8/2025. But on that day, my engaged counsel has some personal difficulty and he took adjournment. And on the next day, 15/9/2025, due to the visit of the Honorable Prime Minister, I couldn't secure leave because I am a resident of Golaghat and the case is pending in Dhemaji.
Where is your petition?
My petition is page number
Adjournment petition.
49.
Where is the Prime Minister's thing? You have not mentioned.
I visited Numaligarh biothermal plant.
For that reason, you could not appear. You have not stated in your petition.
Yeah, it was stated.
Where?
Yeah, para 2, may I read also, that due to the yesterday visit of Honorable Prime Minister of India, Sri Narendra Modi to the Numaligarh refinery Golaghat, the defendant of the case couldn't be able to be present before this honorable court today because I had to leave Golaghat one day ahead of the fixed date because there is a around 4 to 5 hours of journey, I believe.
You have to pay cost. Heard.
I'm ready, but that maybe on a reason, so that I can afford it. I'm ready to pay the cost.
Heard Mr. B. Bora, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Anupam Borkotake, impugning the order dated 15/9/2025, passed in title suit divorce number 26/2024 by the Court of London District Judge Dhemaji, whereby the prayer for adjournment on that day made by the present petitioner was rejected, and the evidence of plaintiff side was closed, thereby depriving the petitioner from cross-examining PW2. Learned counsel for the petitioner who filed the divorce suit.
My wife.
Learned counsel for the petitioner has submitted that the respondent is the wife of the present petitioner and who has instituted a divorce proceeding in the court of London, District Judge Damaji, which has been registered at title suit divorce number 26/2024. He submits that on 15/9/2025, the said title suit was fixed for cross-examination of PW2. PW2,
PW2, brother of the petitioner, wife.
who is the brother of the petitioner's wife. He submits that on that day, the petitioner could not attend the court as he had to remain busy due to visit of the Prime Minister of India to Nimaligarh refinery. And as he is presently posted as
Senior engineer.
senior engineer in the said refinery, he could not get leave on that day. However, leave on that day, stop. And to that effect, he had filed a petition seeking adjournment. However, the trial court by the impugn order has rejected the prayer for adjournment and closed the plaintiff's witnesses and proceeded and fixed this case on next day for examination of defendant's witnesses. Learned counsel for the petitioner submits that the cross-examination of PW2 is vital to the case of the present petitioner. And if he is not allowed to cross-examine, he would be greatly prejudiced. He submits that greatly prejudiced. Stop. He also submits that though in the impugn order it has been reflected that the cost imposed on him on earlier occasion has not been paid. However, he has already paid the said amount. Whether you have paid to your counsel is not our lookout. You have to pay to the court. If your counsel has not paid, then
For that, I paid through my engaged funds.
that is not reflected in Caliculus through his engaged counsel to the court. Stop. I have considered the submissions made. No, learned counsel for the petitioner has further submitted that the aforesaid title suit, aforementioned title suit, is fixed tomorrow before the trial court for cross-examination of defense with DWs. He submits that he is ready to abide by any condition. However, unless a chance of cross-examination is given to him, cross-examining the PW2 is given to him, he would be highly prejudiced. Stop. I have considered the submissions made by learned counsel for both sides, learned counsel for the petitioner, and have gone through the materials on record. It appears that that the trial court rejected the prayer for adjournment by the present petitioner, mainly on the ground that the present petitioner has been taking adjournments at every stage of the proceeding, and he has not paid the costs imposed on him by order dated 6/6/2025. Further, the ground stated by the petitioner in his adjournment application was not found to be a satisfactory ground by the court. Stop. It however appears that the suit in question is a divorce suit which may sever the matrimonial consequence of which may be severance of the matrimonial relationship between the petitioner and his wife, and therefore the petitioner, in the considered opinion of the court, may be granted at least to cross-examine the plaintiff's witnesses. This court, considering the nature of dispute within bracket matrimonial dispute, which is there between the parties, is inclined to allow this revision petition by providing that the petitioner may be allowed to cross-examine PW2 on a date to be fixed by the trial court, subject to payment of a cost of rupees 5,000. In addition to the cost, in addition to payment of the cost which was imposed by the trial court by its order dated 6/6/2025. If you have already paid, it's okay. 6/6/2025. Since this application is allowed by imposing costs which shall be paid by the petitioner as a condition precedent to his cross-examining the PW2, and on payment of such cost, same shall be given to the respondent number 2 by the court. Anything else?
That will suffice.
As the costs to be paid by the present petitioner is to be given to the respondent, this, and as the title suit number 26/2024 is fixed tomorrow before the trial court, this, with above observations, this civil revision petition is disposed of without issuing notice to the respondents.
Here, what's it, regarding the cross, DW, so I'll, we'll submit DW after cross examination of the PW2. So that our defense remain with us.
No, that will be the, otherwise that is the procedure. First your,
Cross examination of PW, then PW.
it is hereby made clear that subject to payment of cost on the next date fix, you pay tomorrow itself. On the next date fix, that is on 21 November 2025. The petitioner shall first be given an opportunity to cross-examine the PW2, and thereafter the court shall proceed with examination of DWs.
Your Lordship, this may be taken up at 2 o'clock. 2 o'clock, I have difficulty, man. This is the,
What is the issue?
is regarding the enhancement of maintenance, I guess that the petitioner has. There are two issues to be, my lord, considered by your Lordship. One is whether that application for enhancement was maintainable before the,
Your husband,
my lord.
You are-
Yes, and the second issue is, my lord, without there being any evidence on record, the income of the husband was, my lord, decided on that basis, my lord, the maintenance was enhanced from 3,000 to 9,000 rupees.
from 3,000 to 9,000. Now what is to be done when
There
we,
will be some other thing, my lord, because 2 o'clock, I'll have a ordered matter, my lord, if that is taken up, that may take the
Okay.
entire day.
then we are adjourning this.
Then on 24th. I'm not asking for.
Is there
anything.
any stay?
No, my lord, there is no.
Thank you.
There is only that recovery part, my lord, for the area that has been stayed. Recovery of areas. Recovery of areas for 72,000 rupees from the date of the, my lord, the earlier arrears. That was. the-
But regular 9,000 you are paying.
Yes.
Then let it be on some other day. Monday we are not. We are already,
I am asking for any fixed date, my. 26. Then.
Norman,
Wednesday.
1st of December. Heard Mr. M.K. Chaudhary,
First, my senior will not be here, some other day.
Norman আমার খালি থাকা চাই দিব 10th of December. Also heard Mr. S. Datta, learned counsel for the respondent. Stop, learned counsel for the respondent prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. To which learned senior counsel for the petitioner raised no objection. Hence the prayer is allowed. Let this matter be listed on 10th of December.
Obliged.
Yeah, please, Madam. This transfer petition is filed for transfer of the divorce was filed by the husband from Dibrugarh to Tinsukia.
Lordship, I have the instruction not to oppose the transfer laws.
Okay.
Only prayer would be, Lordship, there is another suit pending filed by the wife, Lordship, which is currently pending before the learned court, additional sessions FTC number 2, Tinsukia, Lordship, wherein the husband is also participating. This case may also be transferred to the same court, Lordship. It should be convenient to the both sides.
Tinsukia Court otherwise has jurisdiction. Heard Mr. A.K. Gupta, learned counsel for the petitioner. Also heard Mr. D. Das, learned counsel for the respondent. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner, namely Srimati Tina De Sarkar, praying for transfer of title suit within bracket D number 116/2024 from the Court of Learned Additional District Judge within bracket FTC Dibrugarh to the Court of Learned District Judge Tinsukia. The learned counsel for the petitioner submits that the petitioner is a resident of Tinsukia and is the wife of the opposite party. He further submits that the opposite party, who is the husband, has filed a divorce suit in Tinsukia, in Dibrugarh. What difficulty otherwise you have shown?
Financial difficulty as well as the difficulty in traveling, my lord. And my lord, another suit is already pending at Tinsukia.
She submits that the petition, he submits that the petitioner has also filed, what suit you have filed?
For nullity of marriage, my lord.
Has filed a suit for declaring the marriage between the petitioner and the opposite party as null and void. Same has been registered as title suit number.
Title suit within bracket matrimonial number 204 of 2024.
And is pending before the Court of London.
Additional district.
Additional district and sessions FTC number 2.
Additional district judge within bracket FTC number 2, Tinsukia. He therefore submits that to avoid it would be convenient if both the suits are tried in the same court. On the other hand, Mr. D. Das, learned counsel for the respondent, submits that the opposite respondent respondent submits that that he has no objection, that the respondent has no objection to the prayer of transfer made by the petitioner, provided the prayer made by the petitioner. He also prays that in event of allowing this petition, the title suit divorce 116/2024 may be transferred to the Court of Learned Additional District Judge FTC number 3, Tinsukia. Number 2, Tinsukia. Stop. Considering the grounds mentioned in the application, as well as considering the submission, considering the fact that respondent also does not have any objection to the said transfer, the prayer is allowed. The additional district and session district judge FTC Dibrugarh is hereby directed to transfer the records of title suit D number 116/2024 to the Court of Learned Additional District Judge FTC number 2, Tinsukia, who shall continue the trial of the said suit from the stage at which it is pending. Now, this transfer petition is accordingly disposed of.
Will you fix a date for appearance of the parties in?
Yes, since,
Otherwise, Lordship, the other suit is pending tomorrow, Lordship. Fixed tomorrow.
no,
In suit.
we'll give some time.
Lordship.
Since both the parties are represented by, before this court by their engaged counsel, hence both the parties are directed to appear before the Court of London, Additional District Judge FTC number 2, Tinsukia, in connection with title suit divorce 116/2024 on 18th December. 18 December, the Additional District Judge Dibrugarh is directed to ensure that the records reaches the court of records of the aforesaid case reaches the Court of London Additional District Judge FTC number 2 Tinsukia before the said date.
Oh,
Lordship, in fact, the scan copy of the LCR was called for on the last occasion. My lord, my learned friend also wanted to file objection to the FAO as well as the interim prayer for stay of the injunction order. Actually, it is a case against an injunction order which was made absolute. No objection has so far been filed.
My lord, TCR is not received, my lord, and my lord, I will file my objection by the next week, my lord. I have sent in for signing, my lord, he is not able to come. 7-11, there is office.
Heard Mr. L. Talukdar, learned counsel for the appellant. Also heard Mr. A.K. Gupta, learned counsel for the respondent. It appears from the office note that the scanned copy of the trial court records which were called for have not yet been received. Issue reminder for the same, registry to issue reminder. It also appears that no written objection has been filed by the respondent side. Learned counsel for the respondent prays for some more time to file written objection. In this case, the prayer is allowed. Let this matter be listed when after 2 weeks. After 2 weeks on the date to be fixed by the registry. No fixed date. After 2 weeks on the date to be fixed by registry.
Please, Your Lordship. The matter may be passed over for the time being. The learned advocate will engage in another court.
Okay. Okay.
Maybe pass over for the time being.
Okay, after some time we will take.
Okay.
Pass over for a timing also, no lags also. For a timing.
In this case, I am appearing for the respondent. And my, as it is for Ada 41 Rule 10, my scope of argument is very limited. But I am raised here, the maintenance of this, that appeal by the appellant number 1. Therefore, Lordship, I pray that before they come start, the maintainability of this appeal by the appellant number 1 may be heard.
Let him come. Let him come, we'll hear. After some time.
After some.
Item 12.
Eleven keyhole. Well, Dev.
My lord,
Yes,
my lord, herein on the respondent, respondents 1 to 5, my lord, I'm the claimant, we are the claimants, my lord. My lord, actually, the facts of the case are such that
no, what
person-
is this interlocutory application?
my lord, actually, there was an order that was passed by the, one moment, my lord.
What
lord.
for this IA 1615?
Yes, my lord. My lord, an IA under section 173 of Motor Vehicle Act was filed by the opposite party, my lord.
For
My-
what?
My lord, actually, an accident took place where a person lost his life. So the claimants had filed a petition under section 166 of Motor Vehicle Act, my lord. And we were awarded an amount of rupees 4,54,120 with an interest of 6% per annum, my lord. However, my lord, the opposing counsel has refrained from paying the said amount, my lord. And they have filed an IAA, my lord, stating that, my lord, if I may kindly direct your attention towards the said order, my lord.
No, just a minute.
Hey, please, Your
Yes,
Lordship.
what is this?
Lordship, we have made paper publication in respect of respondent number 6 and 7.
What this IA is for?
It's for stay of the impugned judgment, Lordship.
Stay. Okay. No, notice.
We have taken steps to paper publication, but 2 weeks' time may be granted for filing of affidavit, Lordship. That is-
Okay, let us give granted. Heard. Miss M. Saikia, learned counsel for the paper publication in which, in interlocutory application or in MSC main appeal?
237 of 24. MSC appeal?
Main appeal to the
Yes, Lordship. Okay.
main appeal লিখিব বেলেগ order. Heard Miss M. Saikia, learned counsel for the appellant. Also heard Mr. What is your name?
My lord, I'm appearing on behalf of my senior Mr. K. Bhuya, my lord.
What is your
I'm
name?
M. Hazarika, my lord.
M. Hajarika, learned counsel appearing for this respondent number
1 to 5, my lord.
1 to 5. It appears that by order dated 17/9/2025, the appellant was directed to take steps for issuance of notice upon respondent number 6 and 7 through substituted mode of paper publication. Stop. Learned counsel for the appellant has submitted that in pursuant to the directions of this court, aforesaid directions, the appellant has taken steps accordingly, and the notices were already published in the newspapers. However, he seeks some time to file affidavit in compliance of the said order. If prayer is allowed, how much time you want? Let this matter be listed after a week.
Obliged, Lordship. 1, 3, 14, 13, 13.
May I please your lordship?
What is this IA for?
My lordship, it is IA with regard to application under section 5 of the Litigation Act. My lordship, to condoning the delay of 154 days in presenting the appeal, my lordship. We have
Sure.
filed our objection, lordship.
Opposing.
Oppose him because, lordship, they mention about certain document applying certified copy in paragraph 3, lordship, 3, 4, 5, and 7. That they applied for some certificate. They have not even annexed the judgment, lordship, with the petition. And no document about illness, nothing, lordship. Because of depression, mental stress, financial condition, they have mentioned a lot of things, but not a single document. Even judgment is not annexed, lordship. That is why in my objection, lordship, at paragraph 4 and 5, I have mentioned all these things, lordship. Judgments ought to be annexed, lordship, with the delay petition, because delay of what judgment they are seeking, lordship. My lordship,
Yes.
in the, actually, my lordship, we have filed, I admit to my senior, my lordship, I have, along with the appeal memo, and there was another, I have filed the delay judgment along with it, my lordship. But here in this, along with the IA, my lordship,
Supporting documents.
my lordship, with regard to, my lordship,
What are the reasons? Why delay occasion?
my lordship. My lordship may be pleased to peruse para number 2 or page number 6, my lordship. My lordship, the applicant herein, my lordship, he has received a pay and recovery notice, my lordship, from the
You are
respondent,
the owner.
my lordship.
You are owner
My
of the.
and vehicle. My lordship, with regard to pay and recovery notice, my lordship, of 9,20,268, my lordship, on 10/12/2024. And after receiving this notice only, the applicant came to know about that there was a case that was pending in the tribunal. And as such, immediately he came over to Guwahati, my lordship. He applied for the certified copies, my lordship. And after receiving the certified copies, he went back to his home place. His home place is at Tinsukia, my lordship. He went back to his home place and there at Dumduma, my lordship. He went back to his home place and thereafter he approached an advocate, my lordship. And thereafter he submitted all the documents to the advocate, and the advocate stated that you are required to file some other documents also. And as such, he applied for the other documents also. And as such, there was a delay in getting those documents and thereafter filing this petition, my lordship. My lordship, while the main issue is that after receiving the copies, my lordship, it has come to his knowledge that the provisions of CPC mandate was not followed while serving the notice, and the court proceeded ex parte against him, my lordship.
Okay. In the main MSC case.
My lordship. It
Okay.
proceeded ex parte against him, my lordship. Lordship,
Okay. Anything else?
Lordship.
Yes.
Right now also, the submission is about documents, lordship. How you, without the documents being annexed with the petition, lordship, how the court can look into those averments, lordship? There is no document, nothing. And judgment, if necessary, they can file additional affidavit or something like that, lordship. But then based on this application, lordship, delay cannot be condoned because submission is also about documents that we applied for documents. As my senior has stated with regard to additional documents, affidavit, I will file an additional affidavit with that regard. My senior has submitted now. No, I am not submitting. What I am submitting
No,
is.
you
this
have,
results from
you
the,
have those
this
documents
case.
with
The appeal memo and all this.
appeal memo, it is there.
Appeal memo and even one after, yes, my lordship. And lordship, because if the judgment is not annexed, lordship, how do I know when was the ex parte order passed against him? Because without, and based on that only, there is no merit. Just because notice was not sent, pay and recovery, maybe there is a violation of
You
policy
submit
condition.
an additional affidavit with a copy of the same to the other side. All documents which you want to rely.
My
Heard Ms. S.G. Barua, learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for respondent number
2 and 3.
2 and 3. Learned counsel for the applicant praise for allowing the applicant to file an additional affidavit to bring on record certain certain documents which are relevant for consideration of the instant interlocutory application. The prayer is allowed. How much time?
1 week time.
Let this matter be listed after a week.
Can you date on 4th December, my lordship? Can you?
Let it be listed again on 4th December.
That's my lordship.
What is this IA 1949?
And there's one more IA we have filed.
Yes.
We are seeking to amend the memorandum of appeal.
New IA. Where is that IA?
I believe it's tagged as per our information.
What is the number?
379.
3719.
One, 3719, I believe.
Yes. This has to be taken up first. What is this?
So we are relying on the same set of annexers that we have filed under IA 1949. And this one we have filed an application for amendment of the memorandum of appeal in the regular second appeal RSA 236 of 2024 under section 100 of the CPC involving substantial questions of law as maintainability and rights of the appellant described in the original suit under section 9 of the Code of Civil Procedure. So therefore, it's a very small perimeter to the perimeter and the ambit is actually very small here. So the question of law that we are trying to bring in the amendment is whether this suit was maintainable the way it was filed and proceeded with.
You want to propose a the additional substantial question of law, or you want to amend?
We have brought in the questions of law that we are trying to bring in is given in page numbers.
Now, what amendment you are seeking?
We are seeking to amend the substantial questions of law, the grounds, and from essentially after paragraph 4.
You want to amend the memo of appeal
Amending memo of appeal.
substantially.
And this is the main point that we are trying to touch. If a piece of land, which is an agriculture piece of land, which is a quotidian piece of land, whether such a case, which is barred under a law, that is the Assam land revenue regulations, can be decided in a civil court, because civil court has jurisdictional bar here. Under section 154.
Where is your proposed amendment?
The things that we are trying to amend is being listed out right from the beginning, actually.
No, you have not specifically mentioned what you intend to amend.
We have mentioned that we are proposing to amend from paragraph 3 onwards, from paragraph 3 to 28 of the 194 IA, we are trying to bring into the appeal memo. And certain paragraphs from here as well, from this IA 3719. Because there is a question of fraud here, that the decree was obtained by fraud. Therefore, all these annexers and all of this.
Mr. Majumdar, you have any objection regarding
I have got serious objection.
amendment of,
Sir, after your lordship, my lordship has
okay,
completed. then
you
I'll
are objecting to it.
Yes, yes, ma'am. There is no procedure prescribed under the civil procedure. We cannot go beyond the civil procedure code. After your lordship heard the parties and your lordship reserved the case for judgment. After that, if
No,
dismissed
it is not reserved for judgment. The,
CAV,
no. The substantial question of law are yet to be formulated in this case. The only on the question whether this case, because this appeal is not yet admitted.
No, correct.
So it
Your
is
lordship-
pre-admission stage.
True, ma'am. Your lordship heard the, I stand corrected, matter. Your lordship heard the matter for finally deciding as to whether any substantial question of law
Whether it,
involves or not.
whether this appeal is liable to be admitted or
Yes,
to be dismissed.
yes, Yes, so the,
Only on that question.
only on that. So if your lordship, after hearing both the parties, decide that there is no substantial question of law involved, then your lordship would dismiss it.
No, my query before I hear her again, that still as the appeal is yet to be admitted. So you have appeared as a caveator.
Right.
Notice are not yet issued to you. Otherwise, the procedure would have been, in your absence, I should have heard the appellant
For the purpose of admission.
for the purpose of admission.
True.
So let us for hypothetically take that scenario.
Right.
That she appears and after she makes submission for admitting the appeal, because of some query posed by the court, she feels that memo of appeal needs to be amended. So can that be done before an order under order 41 rule 11 is passed? It is not yet passed. Neither appeal is admitted nor is rejected.
For that, I'll just refer to section 100 for a moment. Of the civil procedure code. Well, Lordship, kindly have a look at section 100 for a moment.
Yes.
There is section, well, section 100 says, save as otherwise expressly provided in the body of the code or by any other law for the time being code. An appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court if the High Court is satisfied that the case involves a substantial question of law. 2. An appeal may lie under this section from an appellate decree passed ex parte. 3. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Lordship will kindly note.
Yes.
Subsection 3 says it will be admitted. Memorandum of appeal shall precisely state the substantial question of law involved in the appeal. I am emphasizing on the word substantial question of law. Then proceeding further, my lord, to subsection 4, where the High Court is satisfied that substantial question of law is involved in the case, it shall formulate that question. Then 5 says the appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question.
So this stage comes only after formulation of, you can oppose that this appeal does not involve such question.
Yes.
Only at a stage after formulation of the such questions by the, not
That-
at,
Correct.
can it be done at a prior stage?
I'm coming to that. I've understood your lordship's query. Your lordship is possibly trying to say that at the stage of admission,
Yes.
if we have heard the appeal once for the purpose of deciding as to whether this appeal needs to be admitted or not, primarily whether any substantial question of law is involved or not, on that basis, your lordship will admit. If your lordship finds that it doesn't involve, your lordship may dismiss also at that stage without issuing notice to us.
Yes.
Now,
So do you have a right of audience?
absolutely, my lord, that's what I'm addressing. In the first place, your lordship has heard it, my lord, the practice is, my lord, if the
No.
other side appears. I've
I
understood.
got an occasion,
Right.
therefore I'm asking this
My
question.
lord.
Forgetting about the practice, whether
Well-
is there a prescription of law
No, my lord, absolutely not.
that the court should heard, hear the
So far as the admission of the appeal is concerned.
admission of the
My
appeal?
lord, we often argue when we appear for the appeal, that so far as admission is concerned, the requirement of respondent's presence is not necessary.
Not necessary.
Your lordship will decide as to whether it should be admitted or not on the basis of the submissions made by the appellant only.
And on the basis of materials at that stage.
Absolute, absolute. So what I'm submitting today, my lord, is that your lordship has already heard the counsel for the appellant for the purpose of deciding, and your lordship is placed the matter for, your lordship has already said that I am going to pass the order, no further hearing. That stage was over. Now today, there is a change of counsel, and with the change of counsel, the appellant is bringing 2 more applications. I am submitting on that matter. 2 more applications are there. One is for adduction of additional evidence.
No, that will not come. Additional evidence, unless appeal is admitted,
Exactly, my lord. That is my submission with regard to that.
that will come at a later stage.
Yes, once it is admitted,
If the appeal is not admitted,
then that question will
order
come.
41 rule
So, my
27,
lord, that is my submission in respect of that.
that goes at this
Yes.
stage.
So far as this I is concerned, my lord,
Amendment.
yes, amendment, then your lordship, that is why I specifically referred to section 100, subsection 3. I'm just reading once again to go to this other provision, my lord. In an appeal under this section, memorandum of appeal shall precisely state the substantial question of law. So what is required is the statement of substantial question of law. Now the present application is fine under order 6 rule 17, my lord.
Yes.
Now, lordship will kindly see what is order 6 rule 17. Order 6 rule 17 says amendment of pleadings. The court may at any stage of the proceedings allow either party to alter or amend his pleadings in such manner and on such terms as may be just. And all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. So the order 6 rule 17 petition which has been filed today, my lord, or is being considered today, my lord, is not maintainable for the simple reason that order 6 rule 17 applies in a case where the prayer is for amendment of pleadings. My lord, we all know that memorandum of appeal is not a pleading. There is no question of bringing in fresh statement in the memo of appeal, because memo of appeal doesn't contain any averment, any pleading of the suit. Memorandum of appeal is to contain only the precise statement of the substantial question of law. Yes, my lord, at the time of admission when your lordship is hearing, my lord, the appellant can be heard to argue that in addition to what I have argued, there is another substantial question of law which I want this honorable court to frame. That argument is always available, but that doesn't mean that they will amend, because amendment
So
concept
memo of appeal cannot be amended.
need not be amended, cannot
No,
be,
no.
and they
Need not is a different aspect.
cannot be amended.
There is no provision.
No, there is no requirement. There is no requirement. They are always entitled, even after admission, they are entitled in terms of the proviso to take any other substantial question of law. Section 105 provisos, they provided that nothing in this subsection shall deem
That gives a power to court
Yes.
only, court only.
court on, yes.
But suppose they want to bring in some aspect.
Yes, but no, court, naturally, my court will frame a substantial question of law only when the appellant will urge upon the court. Court may on its own motion do it, or if the appellant argues that there is one more substantial question of involved, it is the court, for the court to frame it. Because entire framing exercise is to be my lord, by the court only.
Assuming some factual aspects mentioned in the memo of appeal,
My lord,
in brief,
my lord.
needs amendment.
My lord, there is no question of giving any factual statement in the memo of appeal. Memo of appeal, my lord, contains two things. One, the grounds, and the second, the substantial question of law.
Some amendment is required on grounds.
My lord, what if they, that's what I'm saying, my lord. If they say they have set out certain grounds, and if they think that one more ground is necessary for them to, for the purpose of framing a substantial question, they can always urge orally. There is no requirement of amending it, my lord. I cannot prevent this, and this court will never prevent, this court will entertain it, because after examining the materials on record, the judgment, the evidence, if
No,
your
no.
lordship finds.
I am unable to convey what I want.
My lord,
That regarding substantial question of law, there is no bar.
my lord,
Court has power.
Right.
If upon the materials on record, it feels that apart from the substantial question of law
Right.
mentioned in the memo of appeal,
Right.
court feels that any other substantial question of law is required to be formulated, it can formulate it. Power is there. But suppose some averment, some statement in the memo of appeal requires change
lord,
according.
my subject to correction, my lord, my submission is, appeal memo does not contain any statement of fact. There is no necessity that it will contain any statement of fact. It only, and particularly my lord, in the present facts and circumstances, what they are trying to say is that they want to introduce certain new facts which were not there at the trial stage. There is no counterclaim. Today they want to introduce certain new facts. Based on this, they have filed the application under Order 41/27, initially saying that we want to adduce evidence when there is no factual foundation in the pleading. This is nothing but the attempt to protect the litigation, because they are in possession, there is a decree for recovery of possession. There is a decree for recovery of possession, my lord.
No, but at this stage, there is no stay. Stay is not there.
Because my lord, we have given an undertaking that we will not execute the decree. If your lordship decides the question as to whether it will be admitted or not.
Yes, but that is
Based
not,
on-
that is not reflected.
But that is the,
Yes,
we have given under, that is why we are not proceeding with the execution. Otherwise-
otherwise there is no bar.
There is no bar, my lord.
Then we will need a stay as well. Because we have inherited this case from,
Stay provided your appeal is admitted.
provided our appeal is admitted.
Absolutely, my lord. I just wanted
So
to
we are
submit,
deciding on many aspects here. Once my.
just one more submission. So my lord, if your lordship goes to, just for a
No,
moment,
let her, these were my queries to you.
my lord.
Let her submit her case.
Yes,
Then
no,
you can
ju-
reply.
Yes,
Yes.
just one submission, my lord.
Yes.
If your lordship kindly, anyway, let her make submissions.
Yes.
With due respect to all the years he has spent walking these corridors and presenting himself before this honorable court, one aspect comes to mind: natural justice. First, foremost, natural justice. So whenever we are deciding on something, we are deciding on two things, the rights of the people and the procedure adopted. All his submissions are on the procedure adopted. Where is the rights of the people? He has not touched upon the rights of the people. And that is where I have made all my submissions, all my filings, the rights of the people. So the rights of the people will preside over any procedure. If necessary, law, the books, all of these are the handmaid of the court. The courts can adjust for proper adjudication of justice and to uphold people's rights where it has been infringed upon. The whole institution of this trial court case, title suit 30 in 1998, was not maintainable. That
No, we will not go into the factual details. What for this Miss IA 3719 has been filed
has been filed.
and what amendment you are seeking and what are the legal basis? Whether amendment in memo of appeal may be done.
So in any amendment, in any appeal may be done. The word pleadings has a large ambit. The word pleadings doesn't mean only the plaint pleadings. Whatever we are stating in the memo of appeal also falls under pleadings. When we are trying to bring in a perversity or inconsistency in law, we will take into account that aspect. I may go through my whole of my IA that I have filed, but mostly your lordship will see that I have brought in the different aspects which were not touched both in rights as well as in procedure. So here we are just seeking to bring in the vital point that if this case was not maintainable, how can a court without jurisdiction, beyond its jurisdiction, adjudicate it, take people's properties away, which is rightfully theirs? That is the main point. So here, only one single procedure of law cannot be taken into account because a fraud has been committed. They have obtained the degrees via fraudulent means, by the case which is not maintainable. Since it is not maintainable, and we are trying to bring in those aspects that different regulations of the law of land is preventing them from filing that suit. And that is in para 5. Of the 371 IA, that the appellant begs to state that section 3, 4, and 5 of the BSA is relevant here in the event of such facts of law coming to light, such as the substantial questions of jurisdiction of the civil court, which is barred under section 9 of the civil procedure code, since land pertaining to Khatian Patadar is a matter of Assam Land and Revenue Regulations Act 1886, that is 1886, which has barred civil court jurisdiction under section 154. Consequently, the proviso of section 9 of the civil procedure code bars the jurisdiction of the civil court in such matters of agricultural land. The rights of the parties involved cannot be decided in the civil courts, where the conditions of settlement are still in force, and violation of the unalienable right of the applicants over the record of the rights of mutation under section 40 of the Assam Land Revenue Regulation 1886 for their land. The violation of the rights over the land in terms possession over agricultural land acquired by inheritance, that is section 6, 7, and 8 of the Assam Land and Revenue Regulations 1886 for their land. The Assam, so now I have stated what the section 154 says. The Assam Land and Revenue Regulation 1886, Section 154 states, matters exempted from cognizance of civil court. Number one, except when otherwise expressly provided in this regulation or in rules issued under this regulation, no civil court shall exercise jurisdiction in any of the following. Question as to the validity. A is question as to the validity or effect of the settlement, or as to whether the conditions of the settlement are still in force. B, questions as to the amount of revenue, tax, cess, or rate to be assessed and the mode of principle of assessment. C, the formation of the record of rights or preparation, signing, or alteration of any document containing therein. Claims of persons to perfect partition. In all these above cases, jurisdiction shall rest with the revenue authorities only. So therefore, this case wouldn't have lied. Now, what does Section 9 of the CPC say? It states that courts to try all civil suits unless barred. The court shall have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is neither expressly or impliedly barred. So here, cognizance is expressly barred. Thereafter, we come to the rights. The Assam Land and Revenue Regulation 1886, Section 6 says, rights which may be acquired over land. No right of any description shall be deemed to have been or shall be acquired by any person over any land to which this chapter applies, except the following. Right of proprietors, landholders, and settlement holders other than landholders as defined in this regulation, and other rights acquired in manners provided by this regulation. Section 7 says, right of proprietor. Proprietor shall, subject to the provision of this regulation, have the same rights and enjoy the same privilege in respect of lands included in their estate as they have at the commencement of this regulation. Section 8 states, status of landholders have acquired. 1A says, any person who has before the commencement of this regulation held immediately under the government for 10 years continuously any land not included either in a permanently settled estate or in a revenue-free estate, and who has during that period paid to the government the revenue due thereon, or held the same under an express exemption from revenue, and B, express provided by Section 15, any person who has, whether before or after the commencement of this regulation, acquired any such land under a lease granted by or on behalf of the government, the term of which is not less than 10 years, shall be deemed to have acquired the status of landholder in respect of the said. When any landholder by one person has come immediately by transfer or succession, in our case it is succession, to be held by another, the holding shall, for the purpose of subsection 1, clause A, be deemed to have been continuous, and the later person may, in reckoning the length of his holding, add the holding of claims to be deemed to have acquired any right to or over any estate, as against any other person claiming right to or over the estate. So they have the right clearly defined. Now there is Section 40, record of rights. The settlement officer shall frame for each estate a record of rights in the prescribed manner. Note, the record of right in the Jamabandi based on Sitha and the field map. The note appended to the section shows that right of set a record of right has to be founded on the basis of equal and actual possession. At the time of settlement, the Jamabandi is prepared, which records names of patadar on the basis of possession. So here the rights of the possessor, the landholder, And all of that is clearly governed by this regulation. And civil courts are barred. So any dispute, they would have had to approach the settlement office. So they should have filed for any dispute in the settlement office. The reason they filed this title suit was because when they went there, their applications were rejected. Nothing could show that they have any rights over these lands, which have been inherited by means of succession by the present appellants. That apart from jurisdictional error.
And therefore, they rightly came to see if that is so. If the revenue authority rejects,
The revenue authority rejected their claim and they cannot come to the civil court. They would have to, if the revenue authority rejected anything, they would have to come to the High Court directly. Because the way it works is, first they put an application to the circle officer. Second, they put appeal to the additional district commissioner. And then they make an appeal to the district commissioner, that is, or the revenue board. And thereafter, from the revenue board, it comes to the High Court. So that is the channel they would have had to take. But they didn't take that channel. What they did was they filed a suit which was not maintainable. This, an advantage was taken because of collision of the councils. And it is the settled position of law by any suppression of fact or by any collision or any other means fraudulently, if they have obtained a decree, that needs to be set aside. And that needs to be set aside by doing the due process of law, which we are presently trying to do to the best of our ability. Lordship, if I may continue as to what amendments we want. Technically, we want the paragraph.
going through your amendment application, you have
We have
not proposed amendments.
We have
but
proposed the amendment and we have included the amendments.
That is an entirely new memo of appeal.
From para 14 onwards, we are seeking to amend it. Because there are lots of conflict of interest, I would also bring in conflict of interest here. And since a fraud has been committed, so we have to be given that extra, the court has to take notice under section 51 of the BSA. So
Okay.
So, here in among the grounds that we Lordship will give me just 1 minute so I can finish. So we are hugely relying on section 38 of the Evidence Act, the new Evidence Act, that is the Bharatiya Sakhya Adhiniyam. Here we are saying, we are alleging fraud, and we have been almost successful in bringing in all the relevant facts where fraud has been committed. And we have listed that out in so many different ways in our both our eyes. And we've also filed a criminal case.
What fraud you are alleging?
First fraud that we are alleging is the plaintiff is not his real wife, not the real wife of Jitendra Narayan Bonikko. He never had Rita Day as his wife. And in all the documents they have said, including the plaint, the pleadings say that she is his wife. So she is claiming rights over the land as his wife. So there itself is a big
When it came to your knowledge that she's not your real, this is at the third stage of litigation.
we have
They are
the
relatives.
This plea, have you taken this plea before the trial court or the first appellate court?
the plea was definitely been asked because of the collision. There is this suppression.
Coalition of
The councils.
engaged counsel.
Engaged councils.
Have you stated that?
We have stated this. We've stated this in detail in both the eyes. I'll go through that part as well. Then after the suit was filed, Jitendra Narayan Bonikko was shown as performer defendant. However, he never came to the court. He never filed a single document. And most importantly, the signatures or the document that they are claiming in, the gift deed itself is fraud. So all the signatures or the preparation of the gift deed itself is fraud. So all of these allegations that we are trying to bring in.
So what prevented you from taking this before the trial court and first appellate court?
Because the trial court and the first appellate court was handled by the same counsel. He didn't even file objections for the amendments that they have brought in. And wherever he tried to sabotage the case, if I may use the word sabotage, he tried to sabotage this fact that this case is not maintainable.
When you came to know about this?
March 2025.
How?
After all these documents were brought to me and they explained, the appellants had explained that we have told our counsels that these are the facts and they have not brought it before the court. That is when I came to know after scrutinizing. And there's one more thing. They brought all the files back with them from the previous counsel. So I had to dig very deep into the files, and that's when I found all the documents. Moreover, Gita Day's daughter, Rumi Bonikko, who is the defendant number 1 here, she is represented as the biological daughter of Jitendra Narayan Bonikko, which is another very big fraud.
Which is another?
Which is another very big fraud. She is represented as the daughter of Jitendra Narayan Bonikko. And that amendment was brought in the first appeal.
But before the trial court, pleadings were verified by you. Whatever was stated before the trial court,
the trial court,
you verified or you?
The trial court trials went so haphazard that even the evidence of the appellants were not adduced. So if I say nothing was done as per procedure, total procedural failure because of the collision, number 1, of the council, and somehow they have suppressed all these facts which couldn't
Then
be.
you have to file another suit for alleging fraud,
We have filed a
making
complaint, yes.
the parties on whom you are alleging fraud. The councils are not parties in this case.
The councils are not parties in this case. And that is the reason why we had to
We are at second appellate stage.
second appellate stage. And that is why we are trying to bring in these facts first in the appeal memo, and thereafter get the degrees cancelled, and then go and do the needful if necessary. And if the court is kind enough to take cognizance of the whole fact under section 51 of the BSA, will be highly obliged about that. So fact judicially noticeable need not be proved and facts of which court shall have judicial notice, that is 52. And
Which,
facts,
which facts you are asking?
these facts that we have laid out before the court about the rights of the people and the procedural lapse that the court should have seen, the courts below should have seen.
No, these are not facts. These are your averments, whether they are,
Our averments or our allegations that we're trying to bring in has factual basis and evidence behind it.
Okay.
It's all backed up by evidence.
yes. Anything else?
I do want to read out the grounds and the substantial questions that we propose to bring in for the amendment.
No, you may tell me the gist. I will go through it because. Okay, read the grounds.
For the trial court judgment, title suit 30 of 1998 dated 31st August 2016 is completely per imperium, erroneous, infirm, and perverse. The title suit was not maintainable due to civil court's jurisdiction is barred under section 9 of the CPC. Land of 7 bigha 3 katha belongs to the appellant and the appellant number 1 inherited the same from their father originally. Then she got her name Patian Raiti Patta. So she is a pattadar and settlement documents as she was in possession since 1982. Niva Boniko name is included in the Sitha as well as she has been paying the revenue tax to the government, was overlooked by the court and suppressed due to connivance and collusion of her counsel and the other party. The documentary evidence is on record of the main suit to her rights claim was discarded. So whatever she had claimed was discarded in the on deciding the issues. So there is a lot of perversity and infirmity on the way that issues were decided. It is admitted that the appellants are in possession and the perversity of the other extends to declare such a possession and title illegal. So in the while deciding the issues, the trial court judgment declared her possession illegal. On what basis a court can declare, a court which is barred by jurisdiction, declare a possession illegal? And title also illegal. Can a court of that position decide on the title being illegal? I do not think it has the power. But the trial court judgment and the first appellant judgment are imperium and perverse on this legal framework. Hence, cancellation and setting aside of the impugned judgment and decree is of utmost necessity to correct the judicial error done to the appellant citizens of this country within the justice delivery system. The second one, for that the original suit 30 is not maintainable under section 9 of the CPC since civil court's jurisdiction is barred by section 154 of the Assam Land and Revenues Regulation 1886. The contents of the same are listed above. The ambit of this acts and regulations are well covered by section 52A of the BSA, the new Evidence Act. And here it is stated that all laws in force in the territory of India, including laws having extra territorial operation, will be taken cognizance of by the court. So did the court take cognizance of this fact? Absolutely not. Therefore, hence the findings are irregular due to lack of jurisdiction. Wholly the trial court judgment as well as the appellate court judgment was passed by incompetent courts without jurisdiction or power to decide and or adjudicate the unmaintainable suit. Therefore, such impugned decree and judgment are to be promptly set aside to correct the judicial mistake. And the next one that we are, then the next ground that we are taking, for that on the date of filing of the title suit, the disputed land was already mutated in the name of appellant number 1 as per rights over land, section 6, 7, 8, and 9 of the Assam Land and Regulations Act. So she already had right title and interest in that point of time when this suit was filed. Therefore, records of right as per section 39 and 40 of the Assam Land and Revenue Regulations 1886 as prescribed above, where it is an admitted fact that the appellants are in possession of the land and the land is settled in their names through succession. Whereas in the pleadings, they said they are in possession. So they've lied in the pleadings. The issue of 2, 3, and 4 are poorly addressed. Therefore, infirmity and perversity of the judgment dated 31st August 2016, case number 60, paragraph number 33, brazenly discarded hard documentary evidence of Jamabandi and mutation, ownership, rights, title, interest, and possession of the appellant number 1. The error of the trial court had been contributed by the collusion of the appellant's counsel with the opposite party, because of which he did not defend the inherent rights of the appellant as described in paragraph 32 of the judgment. Many such errors and frauds have been committed in collusion by the appellant's counsel and the parties to grab the said property. Then number 4, I beg to present before your lordship, is that it is not, the title suit 30 is not maintainable as the same was instituted based upon fake documents. So the gift deed number 33, which is wrongly somewhere given as 351, somewhere it's given as 531, dated 22/1997, which was also cause of action by the plaintiff to claim right, title, and interest in possession over the disputed land of 7 Bigha 3 Gatha. The gift deed was executed by the donor without his proper name and signature. So there is no proper name and signature. How can he execute it without the witness of any credible witness? So there was no credible witness either. It can be safely presumed that the gift deed was manufactured in the absence of the donor, that is the plaintiff, since deceased. Because mostly the performer defendant at that time, that is the Jitendra Narayan Bonikka, was to live in his sister's house. So while living in his sister's house, when he gave her deed of declaration and other documents in full name, how can he go and execute a gift deed? So this cannot be right. Waited until his death to prove the same. So a fraud upon the court was committed by the original petitioner Gita De by impersonating as Gita Bonikka. So she was impersonating, who prepared most of the documents after her employer, Jitendra Narayan Bonikka's death, December 2006. So all those documents that we have said about, from Aadhaar card to what were the other things, affidavits, all of that was, perjury was committed in those, and they were manufactured in 2007 after the death of Jitendra Narayan Bonikka. For that, the fraudulent use of fake identification of original petitioner Gita De and her daughter Rumi De, that is Rumi Banik, such as a next of kin certificate, PAN card, voter card, Aadhaar card, to establish false identity as Jitendra Narayan Bonikka's wife and daughter. Whereas Gita was the wife of late Rabindra De and Rumi was the daughter of Rabindra De, to obtain the decrees. So they used fake documents to obtain the decrees. For that, suppression of facts such as petitioner number 1 is the Kotion Rayati. They suppressed the entire fact that she is the Kotion Rayati since 1983. And this is in the knowledge of the defendants. For suppression of fact that the mutation of Gita Bonikka was cancelled due to lacking Kotion rights of her employer Jitendra Narayan Bonikka over 7 Bigha 3 Katha. Suit land which was always casted upon the appellant number 1, and she has exhibited documentary evidence to this effect, which is exhibit number G. Both the trial court as well as the appellate court ignored this vital documentary evidence, which was enough to prove, as per land records, the defendant plaintiff did not have any right, title, or interest in the disputed land. For that, the suppression of facts and concealment of document that Aruna Bala Rai was the wife of Jitendra Narayan Bonikka at the time of execution of the fraudulent gift deed committed by the plaintiff defendants. Even in the written statement filed in the Guwahati High Court in RSA 236 of 2024, the suppression of this fact is eminent. The gift date numbers are mentioned incorrectly. Paragraph 2, which where it is written as 351, but it is found to be 33 of 1997. Suppression of the fact that Jitendra Narayan Boniko was never in possession of the scheduled land. Only his sister, appellant number 1, was in possession of this land and cultivated it herself with hired workers. She had built a house in she is living in with financial help from her husband, but these facts were suppressed and the court failed to bring out the entire truth in the proceedings. Therefore, the impugned judgments are to be set aside on the grounds of fraud, among other grounds listed out in the interest of justice and to correct the wrong done. For the title suit 30 of 1998 was instituted and adjudicated without presence or consent of Jitendra Narayan Boniko. So he did not have any presence or consent. Even in the written statement, suppression of all these facts can be seen, such as the deed of declaration agreement number 4 of 1998 was never cancelled. And it was claimed to be cancelled. The court observed it to be cancelled, but it was never cancelled. And this was the last document executed by the elder brother of the petitioner number 1 before his passing away. That elder brother, late Sri Jitendra Narayan Boniko, in favor of Niva Boniko, was the last document executed by him with his full signature. He never appeared in court to dispute the power of attorney of number 48, dated 12/1/1998, as well as the declaration of deed. And the defendants tactfully suppressed these facts. He never appeared in the court as pro forma defendant. So they didn't know what was going on. The truth is they didn't know what was going on. Counsel used to go, present, come back. They didn't know what was going on. In all this, the fraudulently prepared documents, the name of Jitendra Narayan Boniko appears as Jiten Boniko, reflecting the coercion and fraud played by the caretaker Gita Boniko and the land broker Fukan Odhikari. So Fukan Odhikari is the defendant number 2. Therefore, the impugned judgment is to be set aside on this ground of fraud. For the 8th ground that we are taking is that the decree in title suit 30 and the judgment in 17 is obtained by fraud and collusion of the defendants and the counsel of the petition Abdul Samad. So we have mentioned his name as well. He did not file the various land documents of the client that the defense side to protect the right, title, and interest of the defendant appellants who were in possession of their ancestral land and had all the right, title, and interest and claim over it. While he had the case dragged over 18 years in the Munsif court at Abhayapuri and 8 years in the appellate court in Bongaigaon district, he neglected to get the fake gift deed cancelled. So he also neglected to do that. Particularly, the paragraph 32 of the impugned order of the trial court makes the collusion quite apparent. Therefore, the impugned judgments are to be set aside on this ground as well. And the next ground again comes to the counsel's name and had all the land documents. So I retrieved all the land documents from his files and that it was in his possession, but he failed to file it in the court. He didn't file it, misleading the clients all the while. The land documents were found on the files returned by him upon checking on 25th of March, 2025. So he did not file a counterclaim and he did not raise the objections when Fukan Odhikari, that is the defendant number 2, and Rumi Boniko, respectively, in the 2 amendments. So when these 2 defendants were brought in, even then he did not file his objections. We have come to know that from the order sheets, where provisions of lis pendens would be invoked to block any further complications in the disputed land. As reflected in the order sheet of trial case number 30 of 1998, the amendments were not objected to and no written statement was filed on behalf of the appellants due to the collusion between the opposite party and the counsel of the appellants. That all the criminal indictments, allegations, averments made against the defendants in IA 1949 of 2025 are not contested and refuted. Hence, it may be deemed proven. Therefore, the impugned judgments are to be set aside on the ground of fraud. And the last one, the ground that we have taken, is that the plaintiff defendant number 2 was unlawfully included in the subsequent amendments and in his sale deed 1214 and 1215 duly executed as exhibit number 30 and 31 have no legal bearing status since the seller itself did not have the right title interest to pass on or any other person. Here, the question of law of using criminal means to obtain civil rights comes in play. And then the substantial questions of law, they are not that many. So we have just included, I'm going to be very brief in this. So she has possession for 43 years. That present appellant Nirba Bonikko has possession for 43 years. And the only legal documents that are properly signed by her brother, that is the late Jitendra Narayan Bonikko, is in her name. And the suit itself is barred under the section 154. So whether a Hiraj periodic Pattadar petitioner, land measuring so-and-so, which she acquired by right of inheritance and is in possession for 43 years, can be evicted by a process of civil court without involving the entire Department of Settlement Office and the Revenue Office, whether she can be evicted. So that is the number one question of law, because here rights will preside over procedure. She has rights. The suit should have never been filed. It should have never gone on. People do not know. They need to be educated and made aware. And we understand this has come to happen because of lack of awareness among people. Certainly lack of awareness among the appellants that I'm representing today. So the section 52A of BSA covers cognizance of all laws that the land presently prevailing for the jurisdiction and maintainability. Whether jurisdictional error committed by the trial court as well as by the appeals court is apparent on the face of record. Whether the courts were competent to try the matter due to section 9 of CPC. They are not competent to try this matter. They are totally barred. Mutation matters, matters of settlement cannot be tried by them. Next, whether the highest doctrine of actus corneum nimnium gravitabit would translate to an act of the court shall prejudice no man. This principle holds that a party shall not suffer because of a mistake, error, or delay on the part of the court should be applied on the face of such per incarium. So this, my throat is dry, I apologize. So this decrees have been obtained with such perversity, with such illegal documents, with such fraudulence. The court should have taken notice of that. It is a mistake of the court, and they have ignored the CPC as well as the Evidence Act totally. Whether the section 38 of BSA applies in the judgment and decree in the title suit 30 of 1998 and in the title appeal 17 of 2016, there's a small printing error here, 2016, as they were obtained by fraud, concealment, and collusion of the defendants and the counsel of the petitioner, Abdus Samad. Abdus Samad did not file the various land documents of his client, thereby concealing them from the defense side, and neglected to protect the rights of the defendant appellant who were in possession of their actual ancestral land. And even the courts have found that they are in possession. The courts have found they are in possession. The courts have found that they are entitled because they have filed their Jamabandi. That should have been enough. And had all the titles, rights, title, interest, and claim over it, while he let the case drag over 18 years in the Munsif court and at Abhayapuri and 9 years in the appellate court in Bongaigaon district. this raises a larger question. How are we managing our courts where a case of this type can go on for so many years? Whether the courts have taken into account the documents as described under section 3, 4, 5 of BSA, where adjudicating the matter in respect of possession documents, whether this possession can be declared illegal by a court not competent to decide. The fourth one, whether the substantial question of law regarding cause of action and maintainability of the title suit 30 dated 24/7/1998 was covered up by fraud. It was instituted based upon a fake document, that is the gift deed number 33. Opposite side has mentioned as 351 dated 22/1997. The gift deed cannot be valid since the donor Jitendranath Bonika of the gift deed did not have the right, title or claim to the disputed property to make a gift under section 122 and 123 of the Transfer of Property Act 1882. So he would have to have the possession and title and all of that to be able to make that gift deed. He never had any. He executed a number of different documents, but he never had any of those titles to even pass it on. So possession was also never handed over, and their pleadings are a lie that possession was handed over, since no delivery of possession could be proved. Hence, can the Honorable Court cancel the invalid instrument and declare it null and void? Is another question of law. Whether we can do it at this stage, whether it can be considered under section 51, facts judicially noticeable need not be proved of the BSA and the section 38 of the BSA. There is another vital question of law. Whether there is a cause of action by the present defendants, Rumi Bonika and Fukan Adhikari, valid, who cannot claim the disputed land based upon the unproven rights of the donor. So the rights of the donor was not addressed properly, not proven. Straight away, everything was, all the orders, everything was ignored while passing the judgment. And can that happen? Definitely not. Who never had any right and title and interest can be made accountable for the fraud and committed upon the court by way of submitting fraudulent documents, suppressing facts, and impersonating under the ambit of burden of proof in section 104, that is burden of proof, 105 on whom burden of proof lies, 106 burden of proof as to particular fact, and 107 burden of proving fact to be proved to make evidence admissible. So, Lordship has to take into account all of this evidence act that we need to keep foremost to uphold people's rights, foremost. And these were not taken into account while passing those two judgments. So these vital questions of law have come into play now, and we want to bring in a few more. Whether a fraud upon the court was committed by the original petitioner Gita De by impersonating as Gita Bonika, who prepared most of the documents after her employer's death. Whether fraudulent use of fake identification of original petitioner Gita De and her daughter Rumi De, also Rumi Bonika, such as next of kin certificate. So government documents were falsified, next of kin certificate, PAN card, voter card, Aadhaar card, to establish false identity as Jitendra Narayana Bonika's wife and daughter. Whereas Gita was the wife of late Rabindra De and Rumi was the daughter of Rabindra De as well. To obtain the decree in a is a fraud upon the court should get court's notice under section 51. Facts judicially noticeable need not be proved of BSA and section 38 of the BSA, and under the ambit of section 100 of the CPC to reverse all the unlawful judgment decrees passed, and to take cognizance of such wrongdoing and give exemplary damage caused upon the defendants. It is very much within the power of the appellate court. Whether suppression of facts such as the petitioner it should have been, number 1 is the Khotion Rayati since 1983, and this is and is in the knowledge of the defendants that her name is included in the SITA dated 28/1/2005 in the Khiraz periodic Patta Dar Rayati list dated 31/3/2009. So, although we are bringing all this, at that time, even at that time in 2009, 2005, they could have withdrawn this case, which is not maintainable, but they didn't do so. They continued with it, as well as in the revenue Khotion Rayati for the disputed land dated 22/7/2005. She has been paying the revenue tax to the government, is committed by the connivance of the council and the other party should be considered under section 51. Again, section 51, 38 and section 100 of the CPC of these questions of law has to be taken. Although these appear to be only facts, but these are not. These are questions of law. Whether the rights of someone can be alienated by bringing in different types of process or procedure. Then the next one that we are trying to bring in is that Gita Bonikko was cancelled, that the mutation of Gita Bonikko was cancelled due to lacking Khotion rights of her employer, Jitendra Naran Bonikko, over the property of his sister, Appellant 1. So the Khotion right was never addressed. The Khotion right was the main one. They have adduced the Khotion right to bring in their part, but the Khotion right, how it is exercised, was totally ignored. And they've suppressed about the Aruna Bala right being Jitendra Naran's actual wife, who was divorced from him and who was gifted 1.5 bighas of land. That part is also totally excluded. So there we have brought in this evidence of Miss Case 60.
Finish.
Nearly. Just 5 more minutes. So here again, we are trying to bring.
It's not hearing the case on facts, man.
Let me.
The facts are necessary when there is a fraud. So therefore, we now coming to the last questions of law that we are trying to bring in is again the different concealments that they have made, particularly about possession.
Okay, you have alleged frauds.
Frauds.
How
And
the-
we have also alleged not only fraud and collusion, but we have also alleged that the issues were not decided properly. The issues were not addressed properly.
Your main accusation is of fraud.
Main acquisition of non-maintainability. That it was the title suit, the original title suit, this being a continuous process
How
decide.
this court will decide the question
of maintainability.
of facts regarding fraud, which you have alleged for the first time.
So the fraud that we have alleged for the first time is upon the documents. We have the evidence right here before us, and it is in the IA 1949. So if they had to say anything, that your Lordship is so well aware about how to decide on the evidence. How can I guide you even more? But the maintainability of this suit. the
No, whether in the
original
second appeal,
Yes, in second appeal, we can bring in the question of fraud. We can bring in the question of fraud. A question of fraud can be brought in.
okay,
It brought in any stage.
yes.
Well, I'll be very brief, 5 minutes I'll conclude. First of all, my first submission will be, so far as pleading is concerned, if your lordship goes to order 6, rule 1, pleading has been defined as plaint and written statement and nothing else. Memo of appeal does not contain a pleading. Order 6, Rule 1.
I'll get back to the court on that.
My lord,
You may take your seat now.
second is, my lord, it has been urged that there has been fraud and the lawyers are also brought in, and then the suit is not maintainable. So far as maintainability of the suit is concerned, my lord, my learned friend basically is urging that there is a bar under section 154, which is there in section, the first substantial question of law suggested now, my lord, additionally, that there is a bar of suit under section 154 of the Assam Land and Regulation. And therefore, in terms of sections 9 of the Civil Procedure Code, the suit was not maintainable. If your lordship goes to these grounds, my lord. No, the substantial question of the first one.
Yes, that is one of them.
Yes. And so far as that ground section bar under section 54 is concerned, my lord, if your lordship goes to the plaint, lordship will find that the prayer, first prayer is for a declaration of title, right title interest in respect of Schedule B. Now, if in a suit, my lord, there is a prayer for declaration of title, whether the suit will be maintainable in terms of section 154 of the Assam Land and Revenue Regulation, my lord. If this issue is no longer res integra, there is a full bench judgment of our High Court, my lord. Your lordship is aware. I am still handing over a copy.
What is the citation?
Citation is, my lord, 1989.
1989, 1 GLR 131.
Yes. In the last paragraph, my lord, 1989 1 GLJ, page 37, or 1989 1 GLR, page 139, 131. My lord, the paragraph 22 says, from what has been stated above, we would say that in a matter like the one at hand, civil court's jurisdiction would not be barred in the following cases. 1, 2, 3, my lord, we can skip. 4, where the plaintiff seeks declaration of his title over the land from which he sought to be evicted. So there is no bar. This is a full bench judgment of our High Court, because this question came up earlier. And in a recent judgment of the Honorable Supreme Court, my lord, which this is 2024 SCC online, SC 3845, Abdul Rezak Laskar versus Mafijur Rahman. Your lordship goes to page, paragraph 56, my lord. Straightway, my lord. Para 56.
Yes.
Further, my lord, referring to the judgment of our High Court, my lord. Further, in the decision rendered in Daulatram Lakhani versus State of Assam, reported in so and Gauri Shankar Agarwala versus Madanlal Agarwala, 2010 SSC online Guwahati, the High Court of Guwahati itself has clarified that the bar created by section 154(1) does not preclude the suits based on title to the property from being within the jurisdiction of civil court. So the first substantial question of law, my lord, falls through for not taking into consideration the full bench judgment of our High Court and the recent Supreme Court judgment. So far as, my lord, the fraud is concerned, my lord, fraud is a question of law, a fact, my lord. Absolutely, there is no pleading. And even if my learned friend is trying to pray for leave for adduction of additional evidence, there is no foundation in the pleading. There is no question of allowing this new point to be raised for the first time in the second appeal.
Please. No, suppose at the stage of second appeal,
My lord,
fraud is found.
absolutely, my lord.
How that is to be brought to the notice of the court?
Absolutely, your lordship is absolutely correct. Provided it is, it has come up to the knowledge of the appellant for the first time at this second appeal stage.
Yes.
They have mentioned a date somewhere. but that cannot be prima facie accepted for the simple reason, my lord. The present appellant is the sister of the husband of the plaintiff. She is a
Not the husband.
family member, number one. Number two, at Lordship, I'll kindly take up this memo of appeal, my lord, page 22. Page 22 of the memo of appeal, my lord. Paragraph 3 of the plaint. Paragraph 3 of the plaint at page 22, my lord. Lordship, it's got, my lord. Page 20. Plaint starts from page 20. I am referring to paragraph 3 of the plaint at page 22, my lord.
Origination is from
RSA. In the RSA, my lord, page 20, the
yes,
plaint starts.
yes,
Lord, will kindly turn 2 more pages to page 22,
yes,
paragraph 3 on top, my lord.
yes,
It is part of the averment in the plaint, para 3, that pro forma defendant since dead is the husband of plaintiff number 1. And defendant number 1 and 2 are respectively sister and brother-in-law of said pro forma defendant since dead. Defendant number 3 and 4 are the sons of defendant number 1 and 2. These are the relations, my lord, which they are now disputing today and saying that fraud, etc. Now, Lord, will kindly turn to page 33. Page 33. From page 32, the written statement starts. When page 33.
yes,
Now it's a written it's paragraph 6 of the written statement at page 33, my lord. Lordship got, my lord.
yes,
It says that the defendant denies the averment made in para 2 of the plaint, but admit the relationship stated in para 3 of the plaint. Para 6. As your lordship got it.
yes,
It is an admitted fact. Now, my lord, so far as their arguments with regard to at this second appeal stage, whether your lordship will entertain or not is a different thing, but they are arguing I was in possession, these, that, fraud. My lord, the suit was filed not claiming title to the property on the basis of inheritance. Title of the plaintiff, although she is the wife of the person who was the owner,
the
is
basis of a gift.
of a gift deed, registered gift deed. And whether registered gift deed is a valid or not, it was adjudicated, issue was there. There is a finding of fact that yes, it's a valid gift deed. And based on that gift deed, the suit has been filed and the title to the property has been claimed. Now they are saying that you are not the wife. Even assuming, for the sake of argument, she is not the wife. Title is claimed not on the basis of inheritance from the husband. It is a gift deed matter. And what was the status of the present appellant? He was the permissive occupier, madam. Finding of fact by the courts, 2 courts below, is that he is the permissive occupier. Now he is trying to take all these technical ground that this is a Khatian property, suit is not maintainable, there is a fraud. Now at this stage, they are taking it so easy to allege fraud against everybody, including the lawyer, my lord. In my humble submission, mind, this kind of prayer should not be entertained. Abruptly making a prayer allegation of fraud against the lawyers who fought at that time, some of them have expired now. If you have any basis, please argue that. But simply because your client wants that I should allege fraud against for not filing these document, that document at that stage, You have signed the written statement.
No, fraud can be pleaded at any stage.
Absolutely,
Now,
my lord.
suppose at the stage of second appeal,
My lord.
not to take the facts of this case.
Ah.
In a case,
My lord, I'm not disputing that. What I'm disputing is in the facts of the
no,
case when.
my query is,
My lord.
suppose a fraud has been alleged against the counsel of the appellant and the other side,
My lord.
collusion between counsel or how at the second appellate stage, court will adjudicate that matter. What is the process?
Process is very simple, my lord. If the fraud, they want to allege any fraud, they have to lay a foundation in the pleading.
Where they will lay that?
My lord, in the pleading.
Pleading means
Pleading
you
means
say
I have
that,
said, there is order 6 rule 1,
you say that,
playing in written statement.
but they came to know about fraud at a stage of second appellate stage only.
My lord,
Why?
I should not teach the appellant here, but they should adopt the appropriate procedure if they want to allege fraud. But what is the fraud? That the documents were not produced at that time. You have signed, you have adduced evidence.
The gift that
No,
itself is
please
fraud.
don't interrupt. Please don't interrupt. You have taken sufficient time.
So my lord, if they can make out a case of fraud, then it's a different thing. But fraud on what basis? They are alleging fraud.
No, you assist this court.
My lord, I am assisting.
How
If-
an allegation of fraud, what is the proper way of adjudicating that allegation?
My lord, proper.
Whether by filing a separate suit
My
or
lord,
how it will be
my
dealt
lord,
with at the
my
stage
lord,
of second.
if they have got plenty of avenues, they can always, my lord, challenge the decree by filing a separate suit alleging fraud. There is no bar under the law.
At the second appellate stage,
At the second appellate stage, if they want to say, my lord, that the decree itself was obtained by fraud, and they want to frame it, but for that, my lord, they will have to establish, because fraud ultimately is a question of fact.
fact.
That fact has to be there, and in support of the fact, evidence has to be brought. Today, by filing an application and saying that there is a fraud, unless specifically something, it is very easy to say that I had one document based on which I am saying that since the document was not produced at the relevant time, I am alleging fraud against the lawyer, against the person involved in the litigation. This is not the money for fraud. Fraud is something else, my lord. This is not called fraud. You were aware of the judgment. Let us assuming that one document was not deliberately. I'm using the word deliberately because fraud will come only when the document, which is very relevant, was not brought to the notice of the court deliberately. Then there may be a question of fraud. But here is a case where trial court's decree was there. You have read the decree. You have filed the first appeal. You have seen the judgment, which document was considered, which was not. Then after first appeal, a second appeal has been filed. There also you did not. Today, after the argument is over for the purpose of admission, my lord, you are saying that no, I will allege each and every ground, including mental inability to the suit, fraud, perversity, everything. In my humble submission, my lord, your lordship will not entertain this kind of attempt to protect the litigation unnecessarily when we have got a decree by 2 courts below. That is my submission. If any other submissions required, any other query or lordship has, I'll definitely answer.
So therefore, the application under Order 6, Route 17 is not maintainable. We have to decide this application.
Because Order 6 Route 17 will not be maintainable for 2 counts. One, by
And one more thing, in a memo of appeal of, this is a query from court. In a memo of appeal in regular second appeal, whether grounds are required on only substantial question of law.
for that, you lordship first take Order 41 first, my lord. I'll answer. I owe an answer to this, my lord, because this question has come up. Lordship, first take up order 41. Order 41, my lord. Order
Yes.
41, rule 1, sub rule 2. Lordship has got, my lord. Order 41, rule 1, sub rule 2. May I read, madam?
Just. Yes,
Hello, Order 41 is a chapter for appeals from original decree. That is the first appeal, man.
yes,
Now, Order 41, Rule 1, Sub Rule 2 says contents of memorandum.
yes. Yes,
It reads like this, man. The memorandum shall set forth concisely and under distinct heads the grounds of objection to the decree appealed from without any argument or narrative, and such grounds shall be numbered consecutively. So if it is a first appeal manner from the original decree, then you have to set forth the grounds.
if it is a second appeal,
If it is a second appeal, the Lordship will kindly come to section 101.
101.
100, man.
101 also is relevant.
Yes, sir.
Okay, 100,
100.
section 100.
100 subsection, I read once, my lord, 100 subsection 3, my lord.
Yes,
In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Mala, I need not refer to all the judgments from Chunilal.
101, read 101.
Yes, yes. 101. 101. my lords. Second appeal on no other grounds. So,
Therefore, I ask question,
my lord,
whether order 41 is applicable in second appeal also. Whether grounds
no,
have to
no,
be.
no, no. The word ground is mentioned with special reference to section 100, my lord. Lordship will kindly say, no second appeal shall lie except on the ground mentioned in section 100.
In section 100 clause.
100 yes, my lord. Substantial question of law. The ground here is with reference to the substantial question of law mentioned in 100 subsection 4. And my lord, Supreme Court has clarified time and again that only on substantial question of law, second appeal will be admitted.
I need more time for preparation because I have disputes with his governments. And at that time of filing this suit, some of
No,
the
you will not get unlimited time.
I will not take unlimited time.
I have given sufficient time to you
But
without interrupting.
that's true, that's true. But I need some time to prepare, go back and prepare and come back for to counter his arguments.
No. I'm deciding this. I'll consider your submissions.
I need a little time to come back with some more things that I'm actually preparing.
Regarding,
Regarding how a fraud and most importantly.
no, you should have come prepared today. You have given sufficient,
I didn't get much time, Lordship. Why I didn't get much time, I must tell you, that because I was this is a very complicated issue. And so I'm having to shift through a lot of materials of not only our High Court, but other High Courts and the Supreme Court. So therefore, once I'm shifting through so many case laws, and once I'm going through so many materials.
okay, I'm fixing it for delivery of orders. On this interlocutory application I'm disposing of on a fixed date. Before that date, no hearing date. You can give.
Before that, I can give.
You can give in writing with a copy to the other side in advance. Any additional thing which you want to point out. Heard this interlocutory application. Heard Miss A. Sakya, Learned Counsel for the applicant in, this is in 3719. Applicant on the interlocutory application under Order 6, Rule 17 of the CPC 1908. Filed by the appellant seeking amendment in the amendment of the memo of appeal in connected RSA number 236/2024. Also heard Mr. D. Majumdar, learned senior counsel assisted by Mr. B.J. Mukherjee.
And you out as well.
Learned
South. SAUD.
only one counsel.
Assisted by.
Learned counsel for the applicant submits that she has some other points to make in support of her submission. Since considerable amount of time was granted to the learned counsel during hearing of this interlocutory application, the counsel is requested to give her some additional submission in writing with a additional submission in brief in writing with a copy of the same given in advance to the others, learned counsel for the other side. When will you give?
I need a fortnight.
no.
I'm on leave from 1st till 12th. So
No,
anytime,
so much indulgence you cannot get.
Lordship, only one small details I'm asking for, because I'm having to shift through a lot of materials. So
Then you
therefore,
should have requested for an adjournment at the very beginning today. That you are not ready, that would have been the
Perhaps.
proper course.
perhaps I should have done that.
You cannot afford to waste court's time.
I won't, because we are giving it in writing. So all I'm seeking to do is, if I may give it on 12th.
Only additional
Additional.
submission. I have taken notes. List this. On on 16th of December, delivery of orders. And you will have to submit before 9th of December.
Okay. 9th of.
List accordingly.
Lordship, I have a request in regard to item number 21 that was fixed on 2/12. Can it come on 9/12?
You inform the other side.
I'll inform the senior counsel. And Mr.
No,
Sahiwal.
first you take information, then you mention it to
Obliged.
29. Heard Mr. B.D. Goswami. We may not give a fixed date after 2 weeks. So Learned counsel for the appellant who prays for an adjournment, as there is unlikelihood that the item may reach hearing, as the item may be taken, as the matter may be taken up for hearing today.
My friend appears for this.
I am for respondent. Lordship, I am
Miss, what is your name?
E. Devi.
E. Devi, learned counsel for the respondent, does not have any objection to this thing. Considering the submissions, The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by the registry.
Ma'am, please, Your Lordship.
Similar prayer for 30-31. In fact, the council is also there. He is also of the view, Lordship. It might not reach today. So a date. Otherwise,
very
I
long.
already have 2 more hearings, Lordship, before that.
Unlikely, it may not reach. They
May
will
not
reach.
reach, Lordship. 27 also is 30-31.
After 2 weeks,
27, 30, 31.
27. You have informed the other side.
Your Lordship.
27, we will not pass orders.
Okay.
30, 31,
Okay, Lordship.
other side have been informed.
But he informed me that today it might not reach, so I'll mention, but he has not reached
Okay.
here yet.
Heard Ms. R.D. Majumdar, learned counsel for the respondent in item number 31 and appellant in item number item number 30 respondent in item number 31 appellant who prays for an adjournment. She submits that she has informed the learned counsel for the other side.
No, Lordship, the learned council informed me that
Same thing.
it is not the same thing, Lordship. I'm not asking for an adjournment. Lordship may, otherwise
Okay.
when it reaches, Lordship. If I take adjournment, the thing is claimant will be that I'm taking adjournment. Otherwise, I'll wait, Lordship. I have to otherwise also wait for 27. No issue.
This, due to paucity of time, this matter
Yes.
is not taken up for hearing today. Let this matter be listed after 2 weeks.
Highly obliged.
May it please, Your Lordship. Your Lordship, I beg to mention item number 10, Lordship. With the consent of the other side, we pray for adjournment for today and then matter will be taken up next week, Lordship.
Heard Mr.
That's one.
As for
Item number, some issue was there.
Yes.
We'll take it up, maintainability.
So far the appeal and admission appeal. I have, I could not say, stay at this stage of order 41, my submission will be very limited on that, because they are to argue their substance, because already in earlier case, the lordship has gone to all the provision. But now they said he is a problem for his senior.
Heard Mr. Bakhtiar, S.
say back to you.
S.A. Bakhtiar, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. Also heard Mr. P.P. Borua, learned counsel for the respondent, who raises no objection to the said prayer. Hence, the prayer is allowed. Let this matter be after 2 weeks.
Lordship, next week.
Any
Lordship.
day, any day.
Next week.
Any day,
Next,
Lordship.
when?
Next week, any day, Thursday.
Why next week?
After 2 weeks.
What is the urgency?
Mhm.
Don't make prayer just for sake of making it.
After 2 weeks. Lordship.
After-
That will be better.
After 2 weeks. If there is some urgency, you have to mention it
Month.
after 2 weeks on a date to be fixed by registry.
Deep level.
May it please your lordship, regarding the mentioned matter, that is item 21. As the matter was fixed on 2nd of December, your lordship, one of the council is not convenient, therefore we have taken consent and they have agreed to come up for listing on 9th of December, lordship.
Item number 21, already mentioned on 9th of December.
Highly obliged.
Instead of 2nd of December, 9th of December.
Obliged.
Item 6.
case, my lord, earlier they were personal appearance, they appeared personally 3 times, my lord. Now, my lord, they have decided to settle the matter, my lord.
You are not pursuing. You are,
Now, my lord, my humble prayer is that the lordship may fix up another date for the last sitting, and on that date, both of them will come, and then your lordship may finally close the matter.
okay. No, they are,
Because they have
Others-
just decided, yes, that they will, my lord, settle the matter, they will reconcile, my lord. Only for the sake of their.
then
children.
you may withdraw the appeal on the next date.
Yes, my lord, on the next date, if it is settled, finally
Okay.
settled.
Heard Ms. S.V. Chaudhary, learned counsel for the appellant, who submits that an effort of amicable settlement between the parties is going on, and there is every likelihood that they may reach an amicable settlement. And therefore, she prays for some time so that the parties may reach an amicable settlement. The prayer is allowed. 2 weeks.
Another date may be fixed, my lord.
Let this matter be listed in again on 16th of December.
Parties come, my lord, before the lordship. So that they can,
No, we have not even issued notice to
well, earlier they appeared twice, my lord, before your lordship.
thrice,
Yes, my lord.
but there is no indication in the,
Lordship, kindly see the order of your lordship, my lord. In 3 occasions, both the husband and wife, they came, my lord.
there is only one order.
So there is my lord.
Matrimonial
My lord,
appeal. No, we will not direct now. Because we have not issued notice. In the appeal,
Yes, my lord, in the.
we have not yet issued notice. So you tell me the result of amicable settlement on the next date, then we will decide what is to be done.
Yes,
Okay. Mandilu, 16th December.
of life. This is the lordship, and this I for delay condemnation application, if you want this delay, may not in filing the regular second appeal,
Any days?
81 days delay. The ground stated in paragraph number 3, 4, 5, 6, my lord. The applicants were not aware of the passing of the judgment. The judgment was passed on 22/2025. The learned counsel engaged in the law who did not inform the applicant about the passing of the judgment. And they came to know about the judgment in the last week of June 2020 after receipt of the execution notice. And in this regard, they have also filed a complaint before the Abhaipuri Bar Association regarding the advocate Miller. So, and on this ground, the delay offered Miller, 81 days delay.
Yes. Anything else?
After the submission.
Yes.
I have objection, lordship, in this matter, and I have filed my written objection also, lordship. Not on the number of days, lordship, on the conduct of the party and the bona fideness of the applicant, lordship. I have filed my affidavit in opposition, lordship. Page 13, your lordship, paragraph 7. They have
Yes.
taken a plea that lordship, confirmation, okay, that their engaged counsel, Mr. Khurshid Raza, was representing them before the learned trial court. but he was not made party in this case, Lordship. So that was my first round of objection, Lordship. In paragraph 7, I have stated
Which case?
in the second appeal, Lordship. He was not made party in the condonation application also, so that Lordship, he should inform the court whether he was negligent in that court or not, Lordship. But they have annexed the complaint before the Bar Association, Lordship.
It is required, no?
Lordship,
Is it required?
already an allegation is against an advocate and he is not aware about.
But he is not party to the case.
In the condonation or Lordship, the impleadment also they can sort for Lordship. They are alleging a allegation against an advocate.
Whether making him party,
It's not mandatory, but Lordship, I have taken a ground that,
and he
He
should
not-
have been made party.
yes, Lordship.
As a accusation, allegations have
Yes,
been made
Lordship, there is
against.
specific allegation that Lordship, due to his activities, Lordship, they were not aware about the passing of the judgment, Lordship, in the title appellate court, Lordship. It is mentioned in their paragraph, Lordship. Paragraph 3, Lordship, they have taken a ground, Lordship. Page 5, your Lordship will find that the engaged counsel, Mr. Khurshid Raja, did not inform the applicant about fixing the case on 22/2025 in their condonation application, Lordship, for pronouncement of judgment. He even did not inform the applicant about the judgment and decree dated 22/2025 dismissing the case of the applicant. The applicant could learn about the impugned judgment and decree dated 22/2025 only upon receipt of notice in connection with the execution case number 5 of 2025 on the last week of July 2025. So I have raised another ground of objection that it is a wrong statement given by the applicant, Lordship, as because they have already, it is already within their knowledge in the first week of July that they are registering the execution, Lordship. Those Lordship, orders passed in title execution cases were annexed by the applicant in the stay petition, Lordship. And from that, I came to know that your Lordship will find annexure 1, page 16 of my objection. I have annexed the order passed in execution case 4/7/2025. Page 16, your Lordship. May I read, Lord?
It's 16 of your objection.
My objection. Lordship.
Yes.
Seen the report of the bailiff whereby it is submitted that the bailiff along with process server Sri Manoj Kumar Rai went to the place of decretal land and met the decree holder who has identified the decretal land, and at the time he met Dhuli along with the drum who was called by the decree holder and accordingly he played the drum to give possession of the decretal land to the decree holder, but the judgment debtor and some local people. So he was there, Lordship. As per report of the bailiff, as per order of 4/7/25, it reflected that when bailiff went, so before 4/7 he was aware, Lordship. But the judgment debtor and some local peoples prevented to do so, and as such he has submitted that assistance of concerned revenue staff for identifying decretal land and police personnel shall be required for execution of the decree by giving possession to the decretal land. So in my humble submission, Lordship, this is not a correct statement given by the applicant in his condonation application, Lordship. And after filing of my this objection petition, one reply was filed, Lordship.
Yes.
Lordship will find page 20 of the reply.
Yes.
Last paragraph, Lordship. Further, the applicant could learn about the impugned judgment and decree dated 22/2025 only upon receipt of notice in connection with the execution case number 5/2025 in the last week of June 2025. But there was a typographical mistake. The applicant in his delay condonation
application in paragraph number 3 mentioned that he could learn about the execution case in the last week of July 2025, which ought to be last week of June 2025. The applicant therefore craves leave of this Honorable High Court to allow the applicant to correct the said typographical error. The applicant states that the said mistake was made inadvertently and bona fide. Now, Lordship, they are committing more wrong, saying that it was in the month of June. Now they are rectifying their mistake by swearing an affidavit before this court. In fact, Lordship, it was within their knowledge in the last week of June 2025, but they made a wrong statement in the condemnation application.
No,
Had it
but
been-
then they are admitting that was due to typographical.
Lordship, if it had been, it is the case of the applicant that had it been their case that it was in the last week of June or first week of June, Lordship, then there occurs some more delay in the condemnation
That
application.
they have not explained.
Yes, Lordship. June to July, Lordship, there was no application. And moreover, Lordship, they have stated in paragraph, page 5, thereafter the applicant applied for certified copy of the impugned judgment on 28/7. So there is a negligence of 1 month period, Lordship.
That 1 month you have to explain.
Now they cannot modify, Lordship.
No,
After
just-
filing objection, they have taken a plea that in the month of June, they were aware about the judgment. And when they were aware about the judgment in the month of June, Lordship, why they have not applied for the certified copy immediately, Lordship? They are negligent. In fact, Lordship, these are the wrong statements given by a
But whether they have to explain each day,
No, Lordship, that I admit. There is no requirement to explain each and every date, Lordship. But this is the Lordship activities or conduct of the parties to be looked into by this court, Lordship. Why they are making wrong statement in every time, Lordship. In the first condemnation application, they have stated that July 2025, but in fact it is
no typographical mistake cannot be attributed to party.
Lordship.
It may
When
be
I-
on the,
That was, Lordship, already at ground taken. When I pointed out that it was within their knowledge, then and only it was modified to saying that it's a typographical mistake, Lordship. I have a strong objection in respect to that also, Lordship. But your Lordship will find the statements made in their condemnation application is very stated that last week of July 2025, and thereafter the applicant applied for certified copy of impugned judgment on 28/7. So it is not a wrong statement, wrong typographical mistake. It is not a typographical mistake, Lordship. In fact, it was correct. But when I objected, then that was modified to a wrong typographical mistake, Lordship. Otherwise, your Lordship will find last week of July 2025, and immediately they applied, Lordship, 28/7. And the entire allegation is on the advocate, Lordship. So my objection is that, Lordship, without making him an allegation was leveled on the advocate, Lordship. Though there was a complaint against that.
suit was for recovery of possession.
No, Lordship. There were two suit by the applicant for right title interest confirmation. And our counterclaim is also for right title interest confirmation.
In whose possession?
We are saying that it is in our possession,
But
Lordship,
then why execution case?
by beating drum for permanent injunction, Lordship.
Okay.
And immediately they have also filed an section 151 petition seeking stay of the judgment, Lordship.
Land is an agricultural land.
That homestead land, Lordship.
Somebody must be in possession.
In my claim, I had stated I am in possession, and therefore I am seeking confirmation of possession.
And I'm relying on some judgment, Lordship. That is, advocate fault is not a ground, Lordship. Should not be taken always as an advocate fault, Lordship. That is 2013-14 SCC, page 81, Lordship. Basavaras and another. Paragraph 12 and 15. And another one, Lordship, that is
Para?
para 12 and 15.
I'm not objecting that every day's delay should be explained and there was a delay of only 81 days. I am on the point that Lordship, the applicant is not stated the statements in his condonation application bona fide delay, Lordship.
Yes,
Para 12, it is a settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigor when the statute so prescribes. The court has no power to extend the period of limitation on equitable grounds. A result flowing from a statutory provision is never on appeal. A court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. The legal maxim dura lex sed lex, which means the law is hard, but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. And after discussing and some other decisions, Lordship, in paragraph 15, it held as the law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have not acted diligently and remain inactive, there cannot be a justified ground to condone the delay. No court would be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by this court in regard to the condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on time, condoning the delay without any justification, putting any condition whatsoever amounts to passing an order in violation of the statutory provisions, and it tantamounts to showing utter disregard to the legislature. Now, Lordship, this Rajneesh and Thirunagalingam, 2024 and 2025 citation. This 2024 Supreme Court decision says in Rajneesh Kumar, Lordship. Paragraph, Lordship, 10, 12, 13. Paragraph 10, it appears that Rajneesh, Lordship, I'm reading from Rajneesh.
yes.
It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long on inordinate delay, as the litigant owes a duty to the vigilance of his own rights. And is expected to be equally vigilant about the judicial proceedings pending in the court initiated at his instance. So here in this case also, he is the plaintiff, Lordship. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. Thereafter, some decisions were discussed. And paragraph 13, in view of the aforesaid, we find
But if advocate is in fact at fault,
in this case,
not in this case, in a case,
Lordship.
then whether in such a case, still whether the party has to suffer.
Lordship, he has. to
There
be-
may be cases where advocate may be at fault.
It is his allegation that he was not, the advocate did not inform him about the judgment, Lordship. It is the duty of the litigant also to take track of their own cases, Lordship. So accordingly, the Honorable Supreme Court held in paragraph 13, in view of the aforesaid, we find no error, not to speak of any error of law in the impugned judgment of the High Court, warranting interference in exercise of our jurisdiction and Article 136 of the Constitution of India. And relying on this judgment, I have already argued a case before your lordship in another matter, lordship. That was also allowed by your lordship. In the third judgment, I am relying, that is Hiru Nagalingam, lordship. That is 2025, para 30 onwards. Mainly paragraph 31. It is well settled law, that is very recent judgment, 2025. It is a well settled law that while considering the plea for condonation of delay, the first and foremost duty of the court is to first ascertain the bona fide of the explanation offered by the party seeking condonation. So I am, lordship, objecting in this case on the bona fideness of the applicant. Rather than starting with the merits of the main matter, only when sufficient cause or reasons given for the delay by the litigant and the opposition of the other side is equally balanced or stand on equal footing, the court may consider the merits of the main matter for the purpose of condoning the delay. Further, this court has repeatedly emphasized in several cases that delay should not be condoned merely as an act of generosity. The pursuit of substantial justice must not come at the cost of causing prejudice to the opposite party. In the present case, the respondent defendants have failed to demonstrate reasonable grounds of delay in pursuing the matter, and this crucial requirement for condoning the delay remains unmet. On this ground, lordship, Supreme Court rejected this condonation application. So these are the three judgments I am relying on. Relying on Rajneesh, I have already argued one matter, that is IS Civil 925/2022, and your lordship has rejected the condonation application. In that case, lordship. But the only difference is that in that case, the name of the advocate was not mentioned in the interlocutory application. But in that case, lordship, they filed a writ petition before the Honorable High Court, but they remained silent in, they had not filed any regular second appeal before this court. Later on, with a condonation application, the second appeal was filed. That case was rejected by your lordship. So my humble submission before your lordship, though there is a delay of only 81 or 83 days, lordship, the conduct of the applicant is not taken to be consideration by this honorable court when he is well aware about the pendency of the execution case. Even then, lordship, he remained silent, and then only he came before this court with this contention.
Yes.
In this case, for the default of the advocate, litigant should not suffer, my lord. I am relying on the
First, you respond to the, suppose your reply is accepted, that you came to know in the last week of June 2025. You applied for certified copy on 28/7, last week of July. This 1 month you have not explained. That is our submission. Not necessary, but that does not mean that you will not explain.
delay of 81 days, my lord. Supreme Court has judgment of Oriental Aroma Chemicals Industries Limited held that liberal approach should be taken when the delay is for short duration. 81 days delay, my lord. And
So
the
81 is a short duration.
short duration.
Okay.
And liberal approach should be taken when condoning the delay, merits of the cases to be so. Recent judgment 2025, my lord.
Heard. Means anything else? Heard
Moreover,
means
lordship, there is a suit and counterclaim, lordship, only one appeal with this condonation.
No, my lord, I have
In the
filed-
meantime, lordship,
I have-
after filing or objection, lordship, they have filed another.
not filing of objection. Before that, I have filed another appeal, my lord.
So again, there will be another condonation application, lordship. There is another second appeal pending, lordship.
in the same matter.
Same judgment, suit was dismissed and counterclaim was allowed. So it ought to be filed two regular second appeal. First, they have filed one regular second
My
appeal.
lord.
Subsequently, another was filed.
What happened, my lord, change of it, earlier advocate has filed one appeal. And I have been engaged, then I have filed two appeals, since that counterclaim is dismissed, my lord. I have taken that ground in that second appeal.
Heard Mrs. Roy. Learned counsel for the applicant. Also heard Ms. R. Chaudhary. Learned counsel for the respondent. This interlocutory application has been filed by the applicant. Samsul Haq. Praying under section 5 of the Limitation Act 1963 for condonation of the delay of 83 days in preferring the connected regular second appeal. The
I am appearing as a caveat, your lordship. There is a caveat.
let's give it a the facts relevant for consideration of the instant interlocutory application in brief are dash dash dash. Stop. Next para. Learned counsel for the applicant has submitted that the applicant has preferred the has approached the connected approached this court by filing the connected regular second appeal, wherein he has impugned the judgment and decree dated 2/20/2025 passed by the Court of Learned Civil Judge Senior Division Bongaigaon in title appeal number 4/2017, whereby the appellate court, while dismissing the appeal with cause, dismissing the appeal with cause, upheld the judgment dated 2/2017 passed by the Court of Learned Munsif North Salmara Abhayapuri in title suit number 45/2013, whereby the suit filed by the present appellant was dismissed and the counterclaim filed by the respondent number 1 within bracket defendant number 1 was decreed. Stop. Learned counsel for the applicant has submitted that the delay of 83 days in approaching this court in filing the connected regular second appeal has occasioned due to the fact that the applicant, due to the fact as the applicant came to know about the impugned judgment and decree dated 2025 only in the last part of the month of June 2025. And he further submits that the engaged counsel for the applicant before the trial court as well as before the first appellate court. No, engaged counsel for the appellant before the first appellate court. Mr. Khurshid Raja did not inform the applicant about the date on which the judgment of the first appeal was scheduled to be delivered. That is 2025. It was also not informed by the council that the appeal preferred by the present applicant has been dismissed by the first appellate court. He further submits that the present applicant came to know about the judgment in the last part of June only when the decree was put into execution, and this you have not stated, that you came to know how you came to know.
Set of the execution notice.
Oh, yes. Came to know. क्या लिखा last line. Only when he received the notice of title execution case
5 of 2025.
number 5 of 2025. Stop. He submits that immediately thereafter the applicant applied for certified copy of the impugned judgment on 28/7/2025, and approached this court by filing the connected regular second appeal thereafter. He submits that the applicant was prevented from approaching this court within the prescribed period of limitation, as the circumstances were beyond his control, as he was unaware about the passing of the impugned judgment and decree in the month of February 2025. She further submits that the present applicant has also lodged a complaint against his engaged counsel, namely Mohammad Khurshid Raja, before the Abhayapuri Bar Association on 4/8/2028, and a copy of complaint to substantiate her submission. To substantiate the submission, the applicant has annexed the copy of said complaint petition along with this case. along with her petition, application. He further submits that the other delay which has been caused has been explained. Other delay caused from the date of receipt of certified copy of the impugned judgment till filing of the instant regular second appeal, connected regular second appeal, has been explained in paragraph number 6 of the delay condonation application. She submits that a litigant may not be made to suffer due to default of his engaged counsel. She submits that in this case, in the instant case, the engaged counsel for the petitioner has defaulted in not informing the date of the delivery of judgment as well as fate of the first appeal filed by the applicant to him within due time, thereby depriving him thereby compelling him to, thereby causing delay in the petition applicant approaching this court to door locker Putul door locker requisition দিব। She further submits that under such circumstances, the court should consider the application filed by the applicant for condoning the delay by taking a liberal approach, as the delay involved in this case is only 83 days. In support of her submission, the learned counsel for the applicant has cited a ruling of the Apex Court in the case of Oriental Aroma Chemical Limited versus Gujarat Industrial Development Corporation and others, reported in 2010 5 SCC 459. So, on the other hand, learned Ms. R. Chaudhary, learned counsel for the respondents, has vehemently opposed the prayer for condoning the delay of 83 days. In this case, she submits that the applicant cannot absolve himself by putting entire blame on his engaged counsel. She submits that as the appeal was filed by the present applicant, it was for him to have remained diligent and to pursue and to keep track of the appeal filed by him. She submits that by merely putting blame on his engaged counsel, the applicant has not even explained the entire period of delay. She also submits that conduct of the applicant is also not such so as to inspire, so as to uh, so that this court may take a liberal view of the matter. Inasmuch as the applicant made a false statement in his application by stating therein that he came to know about the impugned judgment and decree only in the last part of the month of July 2025. She submits that in the where is the notice?
Annexure to my affidavit in
He
opposition.
submits that it is apparent from the order dated 4/7/2025 passed in title execution case number 5/2025 by the executing court that the judgment debtor even before 4/7/2024 resisted the execution of the decree when the bailiff of the court had given the possession of the decretal land to the decree holder. She further submits that this point was raised, when this point was raised by the respondents in their written objection, only thereafter a affidavit in reply was filed by the present petitioner, present applicant, wherein it has been stated that due to typographical mistake, it has been stated in their application that the applicant came to know about the impugned judgment and decree in the month of July 2025, whereas actually it should have been in the last part of June 2025. Learned counsel for the respondents submits that even if the contentions raised by the applicant in his affidavit in reply is accepted, still it appears that the applicant applied for certified copy of the impugned judgment only on 28/7/2025, and the period from a period in between the coming to know in between the last part of June 2025 5. Till the date of applying for the certified copy has not been explained in the application for condonation of delay. She submits that
This was, Lordship, my submission is, this was just a modification to cover up my objection, but
she submits that the contentions raised in the affidavit in reply by the present applicant is only an attempt to cover up the valid objection raised by the respondents in this case. She further submits that it was incumbent upon the applicant to explain properly as to the facts which constitute sufficient cause which prevented him from approaching this court within the prescribed period of limitation. However, the applicant has failed to show any sufficient cause which may justify condonation of delay of 183 days. Therefore, she submits that the application filed by the present applicant for condonation of delay is liable to be dismissed. In support of her submission, learned counsel for the respondent has cited following rulings. Basav Raj and others, number 1, versus Special Land Acquisition Officer, reported in 2013, 14 SCC 181. Thiru Nagalingam versus Lingeshwaran and another, reported in 2025 0 INSC 672. Number 3, Rajneesh Kumar and another versus Ved Prakash, reported in 2024 0 Supreme SC 1101. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the judge rulings cited by learned counsel for both sides. Bankar. On Tuesday, next Tuesday. Heard so and so.
Listed on, fixed on trial court on Tuesday, my lord.
For execution. But the decree is for confirmation of possession.
I am also in possession, my lord, as per I stated in.
Then you need not to fear, because decree is only of confirmation of possession, not for recovery of possession.
moot court decided against the plaintiff in favor of the.
When is the date? Next date?
Next day, 25th.
Okay, on 24th. 24th. But so and so, list this matter for delivery of orders on 24th, 11/2023. Monday.
Filed an application under 151 of CPC. During the pendency of the condonation application, the honorable court may granted status quo order. Filed an application under section 151 CPC that is pending. I have relied on the judgment of this honorable High Court Miller. Status quo to be maintained in the your lordship person order.
No, I am fixing it on before next date, 24th. Considering the outcome of the case on 24th, you may, if delays condone, you may file. Otherwise, it is gone.
Apply.
বাকিগুলা hearing এ আছে। Yes.
Please, your lordship. Okay, there are two appeals, 16 and 17. One is filed by me. On the ground that there is no policy of insurance at the time of accident. The other one is filed by the owner of the vehicle. Claimant. For enhancement of the compensation. My
And you have
appeal
filed-
not directed against the claimant. Claimant will be entitled to get whatever is either from me or from the owner of the vehicle. Lordship, in short, I'll try to make it as short as possible. In short, lordship, this is an accident where according to me, lordship, the insurance policy was obtained after the accident had occurred. The accident had occurred on 6/5/2008.
Evidence is there to that effect on record.
Lordship,
Whether evidence is there
yes, yes.
to show that.
Yes, there is evidence to add, reduced evidence to show that this policy, which was issued on 6/5/2008, was issued with an effective date of commencement of the insurance from 8/5/2008 to 7/5. There are two issues, lordship. One is
When accident occurred, 7.
on 6/5. On
s-
6/5, the accident occurred, and on 6/5 itself, lordship, the policy was obtained. I'll say policy was obtained. It's another thing to say from what time, what date it was effective, lordship. Now, lordship, there can be two issues. Either that policy was obtained before the accident, in that case, there is no doubt. And whether that policy was obtained after the accident. Now, the papers, documents will show that, lordship. Regardless of what I say, you have to come down to the documents that will show that. The other issue that can arise in this case, lordship, is that the policy was issued with an effective date from a future date, like lordship. It was stated in the policy itself, effective date of commencement of the policy of insurance is 8/5/2008. 8/5. 2 days thereafter. Policy of premium was paid on 6/5. The policy was issued with an effective date of commencement. Now, lordship, I'll not go to the second part, whether that, now that's a legal issue, lordship. Whether insurance companies can issue policies with a future date. There's judgments of the Supreme Court. The policy is that it can be issued with consent it can be issued from a future date. It has to be with consent. Now, whether it's express or implied, that's a separate matter. I'll come to that part later. Right now, Lordship, I'd like to show through the documents, Lordship. I'm thankful to my claimant, Lordship, respondent, Lordship, that he has given us a booklet. That will make it easier for the court and as well as me.
Putul, record some.
Record as well as I'll refer to the booklet and also the record, Lordship.
Booklet is there.
Booklet, he has filed.
Yes. Paper book, we have
It's a
submitted the
paper book, Lordship, he has submitted. He has made a compilation of all the,
First. If I,
there is a
No,
compilation. It makes it
Yes,
easier for
yes.
everyone. That's it.
yes.
Very good compilation, Lordship.
No, your appeal is for first appeal. That is 708.
Yes. Motor personal. By United Insurance Company against Sindiras.
Second one. 488.
Lordship, in this case, it's an admitted undisputed fact that the accident occurred at 2:30 PM at Amingaon Dalda factory, in front of Dalda factory. There used to be a Dalda factory earlier, so it is in Amingaon. The owner of the vehicle's official address is Rongia and the policy was taken from Rongia branch office of the United Insurance.
Yes.
Lordship, now I have to say something about the copies of the policy and the certificates which are on record, Lordship. Lordship may refer to page 20 of the booklet, Lordship. It's there in the records. I have checked on the records. I'll refer to some more documents in the record. But here it's easier to find out. Page 20 of the booklet. It's a copy of the policy.
Yes.
And it is accompanied by, on the next page, the certificate of insurance. On the next page. It's called certificate of insurance. The other is the policy with the schedule. How much premium and some details are there.
Yes.
Lordship, may we come to this page 20. And the second part, Lordship, there's two parts. It comes in the A. First page is the second page, Lordship, there's called at the towards the last, Lordship. Date of proposal and declaration, Lordship. 6/5/2008. Lordship, I've seen this particular way. Just above the left hand side rubber stamp, Lordship.
Yes.
Date of proposal and declaration is 6/5/2008. And there is a declaration there by in witness whereof the policy has been signed at Rongia on this day of 6th day of May 2008.
Yes.
So one thing is established here, Lordship. This policy was issued. A date of proposal is mentioned, declaration is mentioned, because every proposal form carries a declaration. And also witness here, the policy has been signed at Rongia on 6th day of May 2008.
Yes.
Lordship, may come to again page 35 and 36. Of the printout, 35 and 36. I just want to show, Lordship, that whenever a document is taken out from the computer system, Lordship, the insurance company has a computer system, the document remains untouched but the printout date is written at the bottom. When anyway, there are 2-3 printout dates of the same document. That's what I have to establish first. Then I'll come to the main document, come back to the original document again. Lordship may see page 35, Lordship,
Yes.
and also 35, both the pages it's written. At the bottom, Lordship may see there is one date, 12/6/2015 at 0.158. This printout was taken 7 years after the accident. At the time for giving evidence. Before giving evidence, they wanted to prepare the affidavit, this policy, printout was taken. If they are always in the printout, the printout was taken.
Yes, what it indicates.
That's why I'll just come to that. And then in the next page also, Lordship,
Printout
Same-
can be taken out at any point.
yes, Lordship. It can be taken out at any point. Now, Lordship, if that is there, there is also another one, Lordship, in the LCR, Lordship. Under page, I also have the same document. Page 34 of the LCR, Lordship. Variants of the same document, Lordship, how does it, yeah, Lordship, variants of the same document. Anyone might say, Lordship, it can be taken at any point of time. If that particular fact is, Lordship, is established, that the time of the printout is written there, then we'll have to come to the original document which the claimant owner has filed before the court, Lordship.
No, are you denying the policy? You're not denying.
I'm trying to establish at what time the policy was issued. Whether it was issued before the accident or after the accident. I'm driving at that.
Do you have anything to show that it was issued after the,
That's what I'm coming.
yes,
That's what I'm coming to. First, I'm saying that what is the nature of these printouts? The printouts, anytime a printout is taken, the date gets automatically printed out. It cannot be changed. So even say after 7 years, the same style remains. That
you feed your computer wrong dates and wrong time, it will show wrong date and wrong.
that
It
is
is
a
very easy.
technical issue.
No,
Uh,
it is very easy.
That-
You change the date setting of your computer and then you take out a printout.
One submission I will accept. Just one submission.
Mr. Lal,
For the-
have patience.
I'm not,
There is
my
admission only,
my
Lord, on this
submissions are not directed against the claimant at all,
No,
Lordship.
what you want to,
I have to show, Lordship, that this policy was taken at 3:30 PM, not at 2:30 PM. 2:30 PM is the admitted time, undisputed time of the accident.
okay, oh, from where you,
Lordship may come to page 21 now. Because once the insured had, owner of the vehicle had come to the office of the insurance company, he had paid the premium. And since he wanted a document, Lordship, it's the first requirement of a vehicle owner. Whenever the policy demands, Lordship, I'll make a small, Lordship, deviation from at this stage to what is the importance of certificate of insurance. Lordship. I'll come to this particular.
page 21.
Page 21 of the write-up, Lordship. Of the
21.
write-up. That's the document filed by the owner, not me, Lordship. The document, Lordship, the question of feeding out that document would not arise because the owner had taken that document with him. 21 of the write-up, Lordship.
Yep.
Page 21. Lordship may try to see, understand my line of work, what I'm trying to.
No, before you show me,
Yes.
on what is your line? What you want to
Yes,
show?
Lordship, I'm coming to that
That-
particular part.
That it was, policy was issued
Issued at
after the,
three-
after
after
the,
the
okay, show
That's
me,
the only point.
show me.
Lordship may come to page 21 of the write-up, Lordship. Because as per the year, this is the document filed by the owner of the vehicle
Yes,
before the tribunal. The part index shows written statement objection filed by the OP2 owner, page 13 to 21. This is the 21 is the document filed by the
yes.
owner of the vehicle. Lordship, the printout at the last line, Lordship may see. 6/5/2008, 3:30.
Yes. So by showing this, you want to
It was taken at
submit that The policy was issued.
Apart from the other side that it was issued from a future date, that will be something. No, sir, I'll just try to create a picture which can be visualized.
This was pointed out to the tribunal.
This was document was filed by the insurance company. The evidence was given on this.
No, this ground which you are taking that.
We had issued it on 6/5. It was effective from 6/5. It was issued after tax. No, sir, may even it's a matter of appeal is a continuous.
No, just
The facts and yellow is there. This document was there. Whether someone missed the, even if that oral submission may have been missed out. No, sir, I'll just take your lordship to the one important document, why this document is the most important document, lordship. 21 is the most important document in this case. Lordship, I'll come to section 158 of the MB Act, lordship. Just to show why it is so crucial to rely on this particular document. Section 158. Lordship, whenever the police authorities or some other, they want to, lordship, sometimes verify it. The police never ask for the policy of insurance. It's a different document from the certificate of insurance. And certificate of insurance has been defined in section 145B of the MB Act. What is the certificate of insurance? And it also includes the cover note. 145B.
Yes.
Lordship may say production of certain certificates, license and permit in certain cases.
Which provision you are reading?
Section 158, Lordship. Production of certain certificates, license and permit in certain cases.
Yes.
Whenever an accident occurs or whenever the police checks the vehicle documents, this is the document the police ask for, certificate of insurance, and never the policy of insurance. Because its certificate of insurance says this policy has been issued in accordance with the MB Act. That's what the authorities want to know, whether this policy, this vehicle is flying with an insurance policy which is issued as per terms and conditions of the MB Act. Lordship, any person driving a motor vehicle in any public place shall, on being so required by a police officer in uniform, authorized in this behalf by the state government, could produce the certificate of insurance. It doesn't say policy of insurance.
Then what do you want to say?
I want to say, Lordship, this certificate of insurance, where the time is written, Lordship, 3:30. It is not, he would not have left the premises, Lordship. It cannot be too much of a coincidence that accident occurs one at 2:30 and a policy is taken at 3:30. The 3:30, Lordship, as I am saying, he has paid the money, must have parted with some documents. This is a document because he has to show the police. Now, when we know on hindsight that there is an accident, this is the document he must have vitally wanted. This is life and death for him. He would not have parted with this because police would not say, they'll say certificate, yes, this vehicle has a certificate. Lordship, the fact remains, even after the accident, the owner did not, maybe whether it's a state that he had not received the notice. But we never bothered to find out also. After the judgment was passed, it was revised on an application that he had not received the notice. The fact is, Lordship, it is such an important document, certificate of insurance. My submission is humble submission. Is that it's very natural, it can be visualized that when he had come to insurance office, paid the premium, he must have left with some documents because why did he consider it necessary? This vehicle it's an old vehicle. It was probably running without insurance. Meets it an accident. And the most natural thing is to desperately look for insurance cover. It was not there. Immediately on Amingaon, Rangia, Lordship, anyone by phone call, I think could have been immediately rushed to Rangia and Lordship this insurance. I'm trying to visualize now how this happened. Why this is, I'm referring to technicalities. It's quite possible. It's too much of a coincidence that accidents occurred at 2:30. The policy is taken the same day when it was not there for such a long time.
These are all assumptions.
No, that
Whether
3:30
evidence is there.
The 3:30 evidence, 3:30 is an evidence. The time is an evidence. That was before the court. The certificate is there before the court. And he has himself, owner has produced this certificate. He files, okay, I put my date and for convenience. The owner has given after 4 years, whatever he had with him, he had received from the insurance company before 4 years. Because he came to the court in 2012. After 4 years, what he has given to the is, it is some credibility loss. That can be believed that after 4 years, owner would give whatever document was given to him on the day of insurance. I'm only trying to visualize what is very natural, Lordship. In the light of human probabilities, Lordship, there is a judgment that sometimes when the evidence is not very clear, either this or that, then it has to be seen in the light of human probabilities, how it would, this decision of the Sumati Dayal versus income tax, then Durga Prasad Moore versus. There are some judgments where the Supreme Court, and the Supreme Court decision, Lordship, when the evidence was not very clear on either side, then it was decided in the light of human probabilities. What would have happened? I'll pass on to judgment, Lordship, Sumati Dayal, and also Durga Prasad Moore. This is so, Lordship. My entire sum and substance of my document is that particular document not filed by me with a tempered altered date, but by the owner, Lordship. And thankful to the claimant, Lordship, he has produced it before the court. It is already there in the court also. Lordship, just to show that every time the printout is taken, a date can be. Now, after 7 years, Lordship, they could have put the date of 7 years back, or they did not do it. It comes naturally. They cannot do it. It's an all India software, Lordship. No one can put that. The content part, printout is, anyone can take out 100 prints. The court requires some, there are 10 cases that are the same extent, 10 times you have to produce before the court. Every time a separate printout, there will be 10 different dates of the printout.
No, apart from your submission that what this date
Yes,
signifies.
that time and date.
No, let me put my question. Apart from your submission as to what this date signifies, is there anything, any other material to indicate as to what actually the date in the last line of the
There's no dispute that it was issued on, it happened, both the things happened on the same day. Policy of insurance happened on the same day, and accident happened on the same day.
what this time signifies?
It was printed at 3:30 p.m.
On what basis you are saying?
The basis of the printout.
No, nowhere it shows, mentions that this is a time of the printout.
Lordship can see 32 and 33, Lordship.
Welcome. His
Lordship, I can only rely on the document that is there on the record, Lordship. I'm not trying to bring in any extraneous material. That document was there. Insurance company has deduced, insurance company was of the firm belief that this accident was here. And they adduced evidence, not that they remained silent, Lordship. This document was also produced by, the same document was produced by the claimant, Lordship. Once, why I, Lordship, undertook this tour of the different documents to show that every time a printout is taken, then why, if now we see that every time printout is taken, it shows a particular time and date both. Then why that cannot inference be applied on this first document? How can the first document be different in nature from the other documents in the file?
no, I am not on that. I am on, apart from your submission, that this time indicates the date, indicates the time when the certificate was actually issued or actually printout was taken out. Apart from your submission, what is there to indicate? What is there on record?
Because the documents are only there, every document carries a different printout time. I can file an
No,
affidavit
no.
to the traffic law. Just to, yes, that's the only thing I can do. What the system shows, every time a printout is taken, I can produce 10 printouts of the same documents on next 7 days and produce it before your lordship. That is the way things operate. I cannot produce anything more than this, lordship. If I have to give it in file an affidavit, I'll file an affidavit to the just to convince the honorable lordship that what I'm saying carries some truth in.
Okay,
If that your lordship permits, I'll file it.
okay, no. No affidavit. Any other
My
submit?
what is good enough about the submission I'm making, lordship. Then I think I have established my point that this accident had made. After, before the policy was taken, or the accident policy was taken after the incident.
Okay,
Accident. Then in this case, lordship, first lordship that I'm relying on is that this why I went to section 158 is to show that this document, there are policies also in the file. I'm comparing instance. Because lordship, I can just say one thing. Anyone who operates a vehicle has to have the insurance documents with it. It's a compulsory document. And police ask for it. And more than the policy of insurance, they ask for the certificate, which is why lordship, certificate insurance lordship, I've read out 158. I'll go to section 145B. 145B, lordship.
okay, no, admitting that police asked for it, what do you want to submit?
And so that that's why this document was required by the insured owner of the vehicle when he paid the premium. Otherwise, he has no proof that his vehicle is flying with insurance. He also, only this document he can show, yes, he is carrying, because the mandate of law that he must carry a policy certificate of insurance. This certificate of insurance was immediately taken from him. He has to give it to the police also, that the police record will also show the same document probably, lordship. So my submission, lordship, is that this was as per our records show, lordship. This policy was obtained after the accident. At that time, we did not know accident because an accident occurred in Amingarh. Some officials sitting in Rangea will not, because hundreds of accidents keep occurring. They will not know. They had no reason to be here. But lordship, when there is no insurance, it comes, someone comes suddenly, they always keep a safety margin.
Whether insurance company adduced any evidence?
Yes. Evidence is there.
There the witness deposed
Cross-examiners.
to this effect that the policy was obtained after the accident.
That was
Whether it was stated.
from the VA.
No need to read. I am asking only.
Both
whether-
policy was issued on the same day.
Lordship,
My,
I'm very sorry.
refresh my memory.
Just 1 second, Lord, please. I'm very sorry, Lordship. My learned friend, what he is submitting, my lord. Suppose I take a policy at 10:30, my lord. I lost the policy. Again, when go to the insurance company, that accident has happened, you give me the copy of the policy. They will take 50 rupees, they will give me the policy of the policy. It will come 3:30, your lordship. On computer timing, the submission, my lord.
So never the contention that he has lost it and come for this
This is
second
never
copy.
the
No,
contention.
no,
Okay,
no,
that's
you can, one
was-
can go on conjuring lots of lottery, but it's never been content by the first copy has lost and this is second copy. Whatever has been given is.
If we even
No,
accept
no,
it,
no,
that-
no,
that-
Now, in order to, this is a very thin line. You are very, my learned friend is very inventive, very intelligent. And he can counter me with a lot of ways, lordship, just to say, throw me off. But it's between you and me and the lordship. He gets it either from me or the owner of the vehicle. The owner of the vehicle to actually lordship to have countered this lordship. My lordship, I'll replace my memory with evidence of what the lordship asked me. What is the evidence? What did he state there? It's there in page 32 of the booklet. This is produced kindly the evidence of the company.
So your main contention is that policy was obtained
Issued
after the
lordship
accident.
after the date,
That is,
after the accident.
and therefore insurance company is not liable to pay. It is the owner who,
That the accident occurs on the same day of the accident, very rare. In this case, we have some evidence to, some reasons to believe, lordship, on the basis of this, that this was actually obtained. 1 hour is a good enough time to, after the accident, it was obtained 1 hour after the accident. Amingarh Rangea is hardly 30 kilometers probably.
okay.
So it was quite possible for the owner to come and take the policy after the accident.
On this possibility, you want to shift the burden to,
Not this
The owner.
possibility. As per my document, this is the fact.
okay,
My document says it's a fact, it's not a possibility.
okay.
I'll also come back again after my learned friend. I have
Yes.
citations to
Yes.
back up my lordship on this point.
We'll start, my lord, with the affidavit by the insurance company as filed, page 32, my lord. This was never the case of the insurance company. After 17 years, my learned senior friend is coming up with this case. My lord. Page 17 is the affidavit. Page 32, I'm very sorry, lord. Page 32 of the paper. It is husband, you want please? It is
Page,
page 32 of the affidavit. Of the paper book, lord, it has. This is the affidavit filed by the insurance company, my lord. First paragraph is the designation, my lord, divisional officer. The second paragraph, that our company has received copy of the claim petition. I had gone through the petition and understood the content thereof. I am appearing today before the honorable court to give evidence on the said case. The claimant is claiming compensation for the injury of the claimant in the accident is 6/5/2008 at under Jalukbari police station, bus number so and so. That the claimant had made United India as the opposite party number 1, alleging that the insurer of the state policy by policy number so and so. That I do say that the written statement has been filed with specifically that vehicle number so and so was not registered with our company at the time of the accident number. The said vehicle was insured with our company by policy number so and so for the period so and so to so and so. That in view of the I hereby state that the opposite party is not at all liable to pay compensation of the vehicle number so and so. In cross-examination is page, they have also annexed the policy number, then we can come to the cross-examination part, which is at page number 44. We have received premium on 6/5/2008. Accident took place on 6/5/2008. Premium received in cash on the date of payment of cash payment in cash policy is given. We did not prefer revision against the vacation of the expiry. As per payment is cash, company is liable. This is an admission on the part of the divisional officer of the insurance company, and they did not bring any evidence to dispute this fact. They could have brought another evidence to dispute this fact, it never. Now, there is judgment of the Supreme settled position of law. Admission is there, my lord. Paragraph 29, if you, lord, paragraph 24, lordship, if your lordship takes up.
page 24.
Page number 6, my lord. Page 6, paragraph 24.
6 of the paper book.
No, lordship, we have given a judgment, a copy of the judgment. This is lordship, Abad Kishore Das, 1979, 4 SCC, 790. Lordship has it, lord.
Yes.
Paragraph 24. Further, what is more important in cross-examination, the defendant was confronted with the declaration in the will. He unreservedly admitted that what was stated in the will was correct. It is true that evidentiary admission are not conclusive proof of the facts admitted and may be explained or shown to be wrong. But do raise an estoppel and shift the burden of proof onto the person making them or his representative in
You are
interest.
reading para?
Paragraph 24, lordship. Of Abad Kishore Das
Yes.
judgment, my lord, 1979.
Yes.
Page number 6, my lord. Lordship has it.
Abad Kishore Das.
Lordship. Paragraph married, my lord.
Yes, further, what is more?
Further, what is more important in cross-examination, the defendant was confronted with the declaration in the will. He unreservedly admitted that what was stated in the will was correct. It is true that evidentiary admission are not conclusive proof of the facts admitted and may be explained or shown to be wrong. But they do raise an estoppel and shift the burden of proof onto the person making them or his representative interest, unless shown or explained to be wrong. They are an effective proof of the facts admitted. So after 17 years of the accident, my lord, my learned friend cannot and should not and must not also be permitted, my lord, to raise a plea which was never raised in the 3 rounds of litigation.
May I, lordship?
No.
No, just started.
Okay.
You are also acting like him.
Yes, lord. I understand.
Company makes
You are more mature than him.
much more lots.
Okay, lordship. I thought while on the point, I'll just.
In the heat of the moment.
Yes, definitely.
In advocacy, it comes up,
That happens.
naturally comes up.
Yes.
Lord.
You may take your seat.
Now, if we go to the facts of the case, Mr. Lordship has heard the matter earlier on length. The contention of the insurance company, my lord, was two. One, the policy was effective from a future date. So they are not liable. This was a new plea that they have stated. Now, if our contention was, my lord, one, if the policy is issued from a future date, you cannot, you must explain that to us. That was not done, so it will not be effective. Second, as per the Motor Vehicle Act, you cannot issue a policy from a future date. And in both these grounds, insurance company will be liable. This was our contention, and we have cited judgment also on that front. I will take your lordship back to that cases, my lord. First, Balbir Kaur judgment was there, my lord, 2009 13 SCC 370.
Yeah, you have given a
We
copy.
have given a copy here. Earlier, we've given, my learned friend also, we have given it to the court also.
Balbir Singh.
Balbir Kaur. Very short, 2009 13 SCC 370. एक clipboard আছে, clipboard ভিতৰত আছে।
Clip to দিয়ক।
Paragraph 9, lordship, if lordship.
Okay, you read. You have to flag.
That will flag up. May I, my lord?
Yes.
Chapter 11 of the Act provides for insurance of motor vehicles against third-party risk. Indisputably, the deceased was a third party in terms of Section 146 of the Act. An owner of the motor vehicle must take out an insurance in respect of a third-party vehicle. Section 147 of the Act provides that the policy of insurance referred to in Section 146 thereof must be a policy which satisfies the condition under Clause A, B, 1 thereof, in subsection 5 of Section 147 reaches so and so. We can skip note. Section 64B is relevant, so I will read me note. But it's intent, no risks to be assumed unless premium is received in advance. No insurer shall assume risks in India in respect of any insurance business on which premium is not ordinarily payable outside India, unless and until the premium is payable and received by him or is guaranteed to be paid by such person in such manner and within such time as may be prescribed, or unless and until deposit of such amount as may be prescribed is made in advance in the prescribed manner. For the purpose of this case, we would assume that an insurance policy in law could be issued from a future date. A policy, however, which is issued from a future date must be with the consent of the holder of the policy. The insurance company cannot issue a policy unilaterally from a future date without the consent of the holder of a policy. Even the said circular letter number so and so has not been produced and no material has been placed as to why the policy was issued from a later date. It is, however, not necessary for us to delve deep into the matter in view of the limited notice issued by this court. Response number 3, the owner of the vehicle, however, has not questioned the part of the order passed by the High Court. He therefore accepts the judgment of the So even if you issue it, my lord, I must be put to notice. That is the honor, my lord. And when there is admission, my lord, so they also admit, my lord, that it cannot be issued from future date. There is circular also of the IRDA which says, my lord, we will place it also on record, my lord, that if policy cannot be issued from a future date. The second judgment is Anush Khalsi, 2022 6 SSC 394, paragraph 14. This is Justice Chandrachud, my lord, same view. Anju Khalsi, my lord, 2022 6 SSC 394.
Okay.
May I read, lord?
Okay. No, the point is clear.
Yeah.
That if it is effective from future date,
yeah,
the insurer has to be informed. Consent has to be obtained.
That's it. Now there is circular of the IRDA, my lord. You cannot issue a policy from a future date.
Circular dated,
Circular, my lord, that date has not come to 2005, my lord. Yes, my lord, Lordship, it is 2005, it has not come in the printout, my lord. We draw your attention to our earlier circular dated 17 May 2028 and 29 2002 on the caption subject. The authority is still receiving complaint regarding non-acceptance of the motor third-party proposal by certain office of the insurance companies. As you are aware, the third-party insurance is compulsory covered as per the Motor Vehicle Act and cannot be denied by any insurer of any vehicle having a valid fitness certificate. In this connection, we also drew our attention to the TSC circular number so and so dated 2003, explaining the basis of rating of the third party liability risk as per metrics considering the individual risk perception and adverse claim experience, if any. You are therefore once again directed to see that no operating office denies third party liability cover to any motor vehicle having a fitness certificate. Please acknowledge receipt and confirm that you are informing all the operating office to comply with direction of the authority.
where is the mention about future date?
Lordship, you cannot issue a policy in our lordship. This is your the authority is receiving complaint that non-accepting of motor third-party policy. You cannot deny. The
But it
moment,
does not mention anything about
Lordship,
future date.
no, the moment you cannot deny, suppose I go to an insurance policy, I say, this is my vehicle, please insure it. You have to insure it from the day it is, I am giving the
That,
claim.
that categorically has not been
That
mentioned.
categorically has not been stated.
What has
but-
been stated is if
You cannot
somebody
deny.
comes for third party insurance, it
cannot
has to be done.
But
But their contention is different.
that inference, I mean, my humble submission would be the inference is that only. This is my submission subject to your lordship and understanding, my lord. That the moment I go to and takes a policy, that the policy has to be issued, that means it has to be issued from the day I go to the office. It cannot be issued from a future date. This is my understanding of this circular subject. to
Is
correct.
there any judicial authority?
Yes, lordship, there are some, my lord. To that respect, my lord, we'll place that on also on the court today. There is judgment, my lord, that we have given a Saran Singh case, my lord. Huh? The judgment is there is paragraph. Now, the second contention is, my lord, that anything when you are issuing a third party policy, it will be void, my lord, from a future date. You cannot, my lord. That is my second condition that will come to that.
Yes.
Lordship has, my lord, 2004 3 SCC 297.
Yes.
Page paragraph 23, page 24. Minalal Ketan, Arun, Oriental Insurance Company, India. Page 24, Lordship.
There are 23.
Para 23.
Yes.
Consequently, different types of insurance cover are issued containing different nature of contract of insurance. We are, however, in this batch of cases mainly concerned with third party right under the policy. Any condition in the insurance policy whereby the right of the third party is taken away is void.
It also is, this is also silent about future date.
Not, this is also silent, but inference is that, not that anything that goes against it will be void. We'll place other judgment that if you issue a policy from a future date, that is void.
Then show that judge. Come directly.
Direct judgment on this point is being none, but
Is there any direct?
no, we are trying to interpret the statute itself, section 146 of the Motor Vehicle Act.
No, whether this question has never been confronted.
No, never been confronted. Till now, I could not find any judgment where this question was raised or confronted or answered.
Okay.
Judgment never. Because if
What has been stated in Balbir Singh?
Balbir Singh says, not only that if there is special condition that if it has to be issued from a future date, then in such circumstances, you must inform the owner and take his consent. It cannot be issued unilaterally. Same Justice Chandrachud judgment also.
So that means that a policy may be issued on future date. Only condition is that the consent of
Lots of, that
the
we
others.
can interpret that
Okay.
judgment on that point. But again, all the judgment that my learned friend has pointed out, even with the Balbir Singh case, Lordship, one thing is common, this point was never raised or answered, that I am raising before you, this honorable court, or any other court. I have done a deep research on the matter. I could not find any judgment which has raised this question, whether issuing of a policy from a future date would be void in terms of section 146 of the Motor Vehicle Act.
After receipt of the premium,
After receipt of
you receive premium on a particular date.
date. Thereafter, you cannot issue a policy from a future date. That is my second limit of submission.
Okay.
Lordship can see the Madras High Court judgment 2012, page 7, page 5, paragraph 7.
Regarding what matter?
The same issue, Milord. From Minalal Khetan, we will come to the interpretation part. From the next judgment, Minalal Khetan, and the second judgment, it will be Scindia Insurance Company. These are the interpretation of section 146. Lordship has paragraph 7.
Yes.
It is an admitted fact that the accident occurred on such and such at certain time when the first respondent, first claimant in all the sea were traveling in the van which fell into the pit injuries. It is seen from Exhibit 5 payment of receipt issued by the appellant insurance company that the amount was paid in respect of the van on such and such, whereas R1 insurance policy states that the policy commences from 00 hours so and so, midnight on so and so. It is noted that R1, that the insurance policy was issued on so and so itself, when the amount premium was collected on so and so, and the insurance policy was issued on so and so. When the above is the position, the insurance company cannot postpone and fix the policy period from so and so to so and so. No reason was given as to why the period is fixed from so and so and so and so, especially when the amount was received and policy was issued on so and so itself. Having received the amount on 27/10/19, it's obligatory on the part of the insurance company to issue insurance
In
policy.
your insurance policy, is there any indication
No,
that it will be effective from 8?
no. Yes, there is an indication that it will be effective after 2 days.
After 2 days?
After.
Okay.
That is what it says, that it cannot be there, my lord. Having received the amount on 27/10/1999, it is obligatory on the part of the insurance company to issue insurance policy immediately commencing the period from the time of receiving premium amount, and it cannot unilaterally fix the subsequent, again, unilaterally comes subsequent time or date at the starting point of the policy coverage. If the contention of the insurance company is accepted, it would be against the interest of public, and moreover, the state contention itself is against public policy. Having received the premium from indemnifying claim, the insurance company has no other option but to accept the commencement of the policy from the time of the receipt of the premium.
Yes.
Now, Minalal Khetan next case, Milord, 1977, QSCC. Here also an agreement was entered into between two parties. The apex court says it will be against law and void, Milord. Shares were transferred, Milord, in this case. I will say para 16 to 21 will be the relevant paragraph.
What point you want to emphasize?
Lordship,
You have already
I will-
emphasized.
Collective
Yes.
citation from my bag.
Yes, yes.
I will.
No, you need not to
Lordship.
cite so many
No,
cases.
this is the, Milord, in this case, what happened, Milord? I will just read one small paragraph. The words shall not register are mandatory in character. The mandatory character is strengthened by the negative form of the language. Now, your Lordship takes a 146 of the Motor Vehicle Act. For a moment, Milord. It is taught in the negative word, Milord. 146 Lordship has been for the moment.
Yes. Yes.
Necessity for issuance of a third party risks. No person shall is mandatory, no person starts with a negative assertion block. So these are mandatory in character and it cannot be bypassed either by the insurance company or by the claimant or by the owner. That is my assertion.
No, they are not denying that there was no incident. They are only saying that the insurance company was, insurance policy was obtained after the accident. That is the,
No, that is not just
there are two submissions they have made, that it is effective from a future date. Alternative submission you have already addressed.
So that you cannot issue a insurance policy from a future date because it will be violative of section 146 of the Motor Vehicle Act.
Yes.
And as an insurance company, you must adhere to section 146 law. That is my submission in precise.
Yes, okay.
For this, Milord, I will refer to the judgment of Minalal Khetan case, Milord.
Yes.
Para 16, I will start from the sub-para. There are two provisions in section 108 of it, as Milord. Page 6.
Para?
Para 16, Lordship, page 6.
Yes.
The sub-para, Milord, from after the allotment of shares, there are two provisions. Lordship has been.
Yes.
There are two provisions or to section 108 of type. We are not concerned with the first provision in this appeal. The second provision starts nothing in this section shall prejudice any power of the company to register as shareholder or debenture holder any person to whom the right to register as shareholder or debenture holder any person to whom the right to any shares or debenture of the company has been transmitted by operation of law. The words shall not register are mandatory in character. The mandatory character is strengthened by the negative form of the language. The prohibition against transfer without complying with the prohibition of the act is emphasized by the negative language. Negative language is worded to emphasize the insistence of compliance with the provision of the act. So and so judgment. Negative words are clearly prohibitory and are ordinarily used as a legislative device to make a statutory provision imperative. In so case, this court referred to various states for finding out when a provision is mandatory or directory. The purpose for which the provision has been made, its nature, the intention of the legislature in making the provision, the general inconvenience or injustice, which may result to the person from reading the provision one way or the other, the relation of a particular provision to other provision dealing with the same subject, and the language of the provision are all to be considered. Prohibition and negative word can rarely be directory. It has been aptly stated that there is one way to obey the command, and that is completely to refrain from doing the forbidden act. Therefore, the negative, prohibiting, exclusive word are indicative of the legislative intent when the statute is mandatory. 17, we can skip 18 minutes, 19 now.
So what is mandatory is the third party insurance.
Third party insurance. Now, para 19 law.
So there is no dispute. He is also not disputing.
I will come to the last judgment, Millard, which says that when the legislature has made third party insurance a mandatory provision, it does not do so for the benefit of the insurance company, for the business of the insurance company.
Yes.
It is to protect the right of the third party. Third party involves the person who works in the road, or travel in the public carriage. I leave it to your lordship discuss, but my understanding to this is that, Milord, that it is a mandatory provision. Insurance company cannot jump it, Milord.
So therefore, in case of third party insurance, a stipulation that it will be effective from a future date cannot be there. That is your submission.
That is my submission.
Okay.
I will just one or two paragraphs examine Lakshmi kindly see for this 29 paragraph 19 and 20, very small paragraph. When a statute expressed or implied is expressly or by implication forbidden by statute, No court will lend assistance to give it effect. A contract is void if the prohibited by a statute under a penalty. For insurance policy, there is a penalty if we don't have. A contract is void if prohibited by a statute under penalty, even without express declaration that a contract is void. Because such a penalty implies a prohibition, the penalty may be imposed with intent merely to deter the person from entering into the contract for the purpose of revenue, or that the contract shall not be entered into so as to be a valid law. We can skip the later part, Lordship, not relevant. 20, if I may read, Lordship.
Oh, you have already made out your point.
Lordship, it is well established the contract which involves fulfillment doing an act prohibited by statute is void. So the court cannot lend its support, my lord, that you accept premium, then you don't allow, my lord, the policy to be effective, my lord. That would be against the statute, my lord. And Lordship has seen a Saran Singh case also, my lord, that anything which goes against the third party right is void. Very expressly said, this goes against the third party right, my lord. A vehicle plying on a road without an insurance, my lord, it goes against the third party right. Involves a third party right, Lordship. And it is a penal, there is a penalty for it, prescribed by law. Fine is there, punishment is also there, 3-month jail imprisonment is there, Lordship. Now, last judgment is, my lord, that insurance policy, the government has not made third party insurance, my lord, for the benefit of the insurance company, my lord. Para 13, Lordship.
Yes.
In order to divine the intention of the legislature in the course of interpretation of the relevant provision, there can be scarcely be a better test than that of proving into the motive and philosophy of the relevant provision, keeping in mind the goals to be achieved by the enacting the same. Ordinarily, it is not the concern of the legislature whether the owner of the vehicle insures his vehicle or not. If the vehicle is not insured, any legal liability arising on account of a third party risk will have to be borne by the owner of the vehicle. Why then the legislature insisted on a person using a motor vehicle in a public place to insure against a third party risk by enacting section 94? Surely the obligation has not been imposed in order to promote the business of the insurers. Engage in the business of automobile insurance. The provision has been inserted in order to protect the members of the community traveling in the vehicle or using the road from the risks attended upon the user of the motor vehicles on the road. The law may provide for compensation to victims of the accident who sustain injury in the course of an automobile accident, or compensation to dependents of the victim in the case of a fatal accident. However, such protection would remain a protection on paper unless there is a guarantee that the compensation awarded by the court would be recoverable from the person held liable for the consequence of the accident. A court can only pass an award or a decree. It cannot ensure that such an award or decree results in the amount awarded being actually recovered from the person held liable who may not have the resources. The exercise undertaken by the law courts would be then an exercise in futility. And the outcome of the legal proceeding, which by the very nature of things involve the time, money, cost invested from the scarce resources of the community, would make a mockery of the injured victim, of the dependent of the deceased victim, who themselves are obliged to incur on a not considerable expense of time, money, so and so. To overcome this ugly situation, the legislature has made it obligatory that no motor insurance shall be used unless a third-party insurance is enforced. To use the vehicle without the requisite third-party insurance being enforced is a penal offense. The legislators were also faced with another problem. The insurance policy might provide for liability worked in by condition which may be specified in the contract policy. In order to make the protection, the legislature provided the judgment options section 146 and 147 law.
Yes.
Now, their last paragraph, the exclusion clause has to be read down by the court, Lordship. Here there is an exclusion clause saying that it will be effective from such and such that has to be not on directly on the context, Milord, page number 12. Yes. Lordship has page 12.
Para?
Last paragraph, just will this not the whole paragraph is relevant with last paragraph, page 12, Lordship. Notwithstanding the general ability of the contracting parties to agree to the exclusion clause which operate to define obligation that exists a rule usually referred as the main purpose rule, which may permit the application of wide exclusion clause defining a promissory contractual obligation. For example, in so and so stated. It seems to me that in constituting this document, which is a contract of carriage between the parties, one must in the first instance look at the whole instrument and not at one part of it. Looking at the whole instrument and seeing what one must regard as its main purpose, one must reject word indeed whose provision, if they are inconsistent with the one assumes.
Okay, you have made your point.
That is my submission on with regard to the policy.
Yes.
So first submission is special condition cannot be unilaterally invoked, has to take the consent. Second, Milord, it is against section 146 of the Motor Vehicle Act, henceforth. And the court cannot lend assistance to make it operative, Milord. These issues, Milord, if Lordship can see, other judgment of the apex court also has never been raised, never been answered. So I'll leave it to your Lordship on that. Now, Milord.
Now your case.
Now my case, Lordship. My hand was empty.
Lordship, that's a case for enhancement, Lordship. My first issue, my case was whether insurance company is liable. Can this be taken up first before going over to his?
Yes, yes. Then we may.
Yes, Lordship, because.
No, Lordship, I would.
My
no,
point is,
okay.
that's it, let's finish this case first.
No, Lordship.
No, we have very time constraint is
It's a
there.
2008 accident.
This,
enjoying a
we
stay
cannot,
order.
we cannot further defer it to another day.
17 years have passed, Milord, from this.
Not my problem. Lordship, I've been saying from the very beginning, Lordship, that my appeal is not directed against. I'm not trying to come in the way of a third party. A lot of submissions have been made on violations of insurance policy terms and I'm not on that at all, Lordship. I'm on one simple issue, Lordship, whether the policy was in existence. I agree with all the judgments he said, whether violation, why insurance company policies are required, so that, yeah, that deals with a situation where there's a policy, but there is a violation of terms and conditions. That's one issue altogether. The other issues that I'm not that there's no policy at that time of accident.
Okay, that submission
That's a
you
different issue
you have already made.
My Lordship, Lordship, I'd like to, at the time I had not completed, Lordship. I'd like to rely on some citations where similar times are there. Accident had occurred in. Lordship, I'll be mindful of the fact that there is limit of time. Lordship, I'll just make one year that all these cases are of the year where the accident occurred just prior to the accident. And what is just then? The insurers are held not liable, Lordship, in all these cases. That under any circumstances, insurance company have to pay. I'm just giving this to, so this submission was made. Come, whether there is policy or not, insurance companies will have to pay. Whether there is a violation or not, insurance company will have to pay. Lordship, what has been, it's a concern of the Supreme Court in various judgments, as well also the government of India, that huge percentage of vehicles are plying on the road without it. It's a fact, Lordship. Lordship wants me to hear, I can probably produce from the sites. There's a huge percentage of vehicles, and there's a concern of the government as well as the court, Honorable Apex Court. So, in order, if I have to listen to my learned friend, that come what may, policy has insurance or not, the Act mandates there should be a policy. If he doesn't take the policy, does he go totally exonerated, scot-free, Lordship?
No, that is not his submission.
Lordship, that's what he is saying, that violations He, if,
No,
in this case.
he's what I have understood, if there is a policy, you cannot stipulate that it will come into effect on a future date.
That is not
Unless-
part of it. There are other judgment, he said, surrounding, etc., this was not there. Yeah, I'm not on any kind of policy violation at all in this case. I'm just kind of on that particular time and date stipulation. On this particular, I'm on a fact, basically, Lordship. Insurance company first evidence, Lordship has seen that policy, I said that on policy is to be effective from a future date, admittedly, I said that, on 8/5. But the fact remains, even if that part of my argument, and Lordship, it also said, which it's not at all, Lordship, the judgment he has relied on, Lordship, Balbir Court. It says para 13, for the purpose of this case, we assume that insurance policy in law could be issued from a future date. It's only certain stipulations there.
Yes.
It's not entirely illegal, or there is no bar that insurance policies cannot be issued from a future date. Lordship.
Yes, then
It's a question-
burden is on the insurance policy.
Yes, Lordship. Insurance
that-
policy can be issued from a future date.
That the consent was obtained.
Yes, that consent, does it anyway say it's implied consent or express consent? Now, there certain situations might arise, Lordship. When he takes the policy and 4 years, he does not object, Lordship, he will let the owner of the vehicle. My learned friend has been making some arguments on behalf of the owner of the vehicle. It's for the owner of the vehicle to come, stand up and say that he had at any point of time, any objections regarding the policy that was issued. That it carries a debt which he had not intended. It carries a debt which was not desired by him. It implies certain situations, Lord, this implied here has meaning has to be taken also.
Okay.
It may not be external, but he has never come. He's come to court 4 years after the accident had taken place. Someone so concerned to get a policy on the date of the accident, or could have been more.
Who is
could have been more,
representing owner?
Lordship, in this context, Lordship, I'll just finish my one. There's a judgment, Lordship, of Devkar Exports versus. The copy of it, I'll give it. Okay, I'll read out and I have a copy, Lordship, but
On what point?
this point, Lordship, particularly this point, if my learned friend, the owner of the vehicle, was not happy with the Lordship policy that was issued to him, it very clearly says what the owner of the vehicle, any policy holder should do when he gets a policy which does not, Lordship, serve his purpose, Lordship. Just one second. It got mixed up with, there's another case I had in. Yes, Lordship, I'll read out. Devkar Exports versus New India Insurance Company Limited, this is the policy. It very clearly says in para 24, probably, Lordship. Para 13, Lordship, please. A policy of insurance, may I read, Lordship, para 13?
Yes.
A policy of insurance is a contract based on an offer, proposal, and an acceptance. The appellant made a proposal. In this case, he was the appellant, Lordship, Devkar Exports. Therefore, it was the respondent accepted the proposal with a modification. Therefore, it was a counter proposal. The counter proposal, the appellant had 3 choices. That's the insured owner of the vehicle in this case. The first was to refuse to accept the counter proposal, in which event there would have been no contract. The second was to accept either expressly or impliedly the counter proposal of the respondent, that is the respondent's acceptance with modification, which would result in a concluded contract in terms of the counter proposal. The third was to make a counter proposal to the counter proposal of the respondent, in which event there would have been no concluded contract unless the respondent agreed to such counter proposal. But in the appellant definitely did not have the fourth choice of propounding a concluded contract with modification, neither the proposed nor agreed to by either. Now see, he had at every point of time He never objected. He had a choice, 3-4 choices. What he could have done if the date was not according to his choice. So some implied, it also is some implied consent can be read into it also. Because it says that is respondent's acceptance impliedly or what it said, either expressly or impliedly. Now he takes a policy, goes out from my office and does not report, come back for 4 years. Only in the tribunal he says it was given.
That is your contract is a standard form contract where
It could have-
without any discussion with him, you have already incorporated the conditions. Yeah.
Right to file is a object. Their insurance company keep receiving and they pass endorsements. They keep saying, this has to be included, this is not included. This is a standard part, this is a standard procedure. Even after policy issued, anyone can come and ask for modification. A standard part. I'm not trying to make it up one bit just for the sake of argument. The standard procedure, and this is assembly. This is also in respect of an insurance company only. But here after the year, they could have done it. No objections have ever been raised that this was incorrectly reflected in my policy. This loss is a very important one. Implied consent was there. So even if the policy was issued from a future date, it had the implied consent of the owner. He never, now lordship, someone has he has a right to object. It's a free country, lordship. Insurance company could not have dictated terms to him. He had the right to walk away from the contract, reject the contract. There are other insurance companies in the same place or ERR. Anyone can, no one can be bound to buy insurance from one insurance company. Now there are lots of 20, 30 insurance.
Oh.
They have free choice. It's a free market, free choice. How can someone be bound even if he's not? It's a standard form. Let's say it should buy lots of tariff advisory committee. No one can even make one dot comma changes. Some policies have been de-tariff, but this is still a tariff policy. So no one insurance company can even impart on its own. It will be a violation of the tariff.
Okay.
They would not do it, and a heavy fines are also imposed for such violations on insurance company. If they breach the tariff, do something that is not sanctioned by the tariff. So Devkar Exports Lordship, I am just pressing for there that he was not without a choice. He did never object to it. That this
So your submission is that implied consent was there
concept for the future date.
for future date.
And as regard the first date, Lordship, when the document is there, whether that written submission was there or
therefore,
not, and whether that particular part of the year he has read. Lordship, it's a general statement, it can be an additional fact. As per payment in cash company, that's a standard. Anyone pays premium in cash, liable. Insurance company at that point of time didn't know that there was an accident. But they cannot say, yes, now we know we are not liable. General standard principle is a principle. Payment in cash, liable. Unless there are some there's always some exceptions. Unless there are intervening factors, that there's suppression of material fact. There are lots of hundreds of judgments on suppression of material fact. That the vehicle had matriculated is a material fact. Material fact is which influences the decision of the insurers whether to accept it. He had declared my vehicle has matriculated accident. He said, no, please, we'll give it from a future date. That's it. So there's a suppression of material fact. So insurance company has this, there's nothing wrong with this cross-examination. As per payment in case, it would be illegal to deny that even after payment of cash, we can probably say it's not liable. It's not liable.
Okay.
Had it not been for the fraudulent lordship, misrepresentation, that insurance would have been liable. But because of this, now we come to know after the year that yes, accident had occurred before this. That 330 was done unintentional lordship. On that day, I have gone through various documents just to show this automatically come out. At that point of time, insurance could never had any motive because they were unaware, blissfully unaware also, that something had happened. They had received the premium and given, okay, whatever. Probably was in too much of a hurry, probably, to get a policy and show it to the police. Lordship, as regards once the term policy is concluded, Lordship, It's not given to anybody to change the terms and conditions. This is a terms and conditions. This judgment, various judgments of Supreme Court, I'll, Lordship, not make it a long argument, but I'll hand over the judgments to your Lordship. That once it's a terms and conditions, it cannot, however one likes it or not, even Supreme Court cannot rewrite a contract. A contract cannot be rewritten by any court in our country, Lordship. Even Supreme Court says it. Even Supreme Court cannot rewrite a contract. Now, it is a contract, a special contract. That was there. That date was there. If no fraud on the part of insurance company, it has not been alleged, is proved, can there be a change in the terms and conditions? Lordship, I'll just not dwell much on it, but I'll pass on a few judgments, Lordship. Just to amend that interpretation of contracts, Lordship. Yes, I'll give you a write-up also on this. भैया ले लो ले लो
You submit the judgment indicating the paragraph which you are
Lordship,
relying.
I have made done the paint to indicate the paragraph and also judgments. The summary, these are judgments are there.
Okay.
I've made a Lordship summary of this. Lordship may refer to this. These are exactly as per the judgment.
Okay.
This it might be slightly longish, but I have to tell you on the nature of insurance contracts another heading.
Now, how much time will you take?
Some time, Lordship, what more, but I have to address this honorable court.
Lordship, just one
Well,
small
I'll
point,
let you-
and I'll give it to him.
You also indicate in a sheet of paper which judgment you are relying, which paragraph, on what point. Yes.
I'll finish it. Just a minute. Lordship, I had talked about some a test of human probabilities.
How much time will you take? We don't have time.
I'll just pass on to judgment and just make one small statement.
Yes.
Leave that to judgment, please. I'll just read out one particular para and I'll not go to other judgments. Same-
On what point?
Just like in a case, Lordship, now the Lordship had inquired what is the other evidence of. Something in a case, I might try to make out a case where evidence might be this way that your court may not be. Then what do the courts do, Lordship?
Suppose evidence is not there.
Then the court also, Lordship, this is a very interesting case, Lordship. If I 1 minute, Lordship.
Yes, take 1 minute.
Lordship,
Stop. Please
then
stop after.
Sumati Dayal, Lordship.
After 1 minute is over, you have to stop.
Then yes, I'll stop that.
Then why?
Yes,
Yes. What is the matter?
Lordship, it's a case, Lordship, where a lady, Sumati Dayal, in this case, had claimed income tax from her earnings from jackpots she had won in several derbies in that country. There was a Bangalore Derby, Bombay Derby, Calcutta Derby, all these horse races were there. And income tax refused to accept her statement that she had won all the derbies in the same year. She sold the Lordship prize winning tickets. That was evidence in her favor. The income tax authorities, how is it possible, mathematically, statistically not possible, she will win all a lady with no experience of horse racing earlier. Their suspicion was that she must have bought the tickets just to convert black into white. That was the suspicion. Matter went up to Supreme Court from income tax appellate authority tribunal to then the Supreme Court. Supreme Court Lordship just came, even if someone tosses a coin, it will not come heads in all, tail in tail all times. That's it. That's the in the light of human probability, Supreme Court decided this is not an earning from evidence was in her favor. Lordship. Evidence was in her favor, she has produced. What could she have done? But experience in the light of human probabilities, Lordship. The human probabilities do not show that someone without any experience of horse racing will win all the derbies in the country. That's why I'm saying, even if Lordship finds that my evidence 330 I'm very confident of my evidence, Lord, 3:30 printout date. There's no motivation on my part to produce that at 3:30. I could have put any time otherwise, maybe delay it even more, 2, 3, 4 hours. Why only 3:30? Why keep a gap of only 1 hour? But I've given this just to say, in fact, the Supreme Court also felt, in spite of evidence, light of human probabilities, this is what accident has occurred. He has come within 1 hour to the insurance company, taken the policy and given it up. That's my assumption.
Okay.
Maybe 2 minutes.
Mark the para, which para?
There are, let's say, 6, 11 and 12, 6, 11 and 12.
Okay.
11 and 12.
Yes.
Read
Yes.
it 6.
Yes, owner.
Yeah. In the clash between the owner and the insurance company, my compensation against me.
You have not received anything.
3 lakhs I have received for my petition of my right. And
How much was granted?
6 lakh something was granted. We are fine.
50% you have received.
There is a year
And
rider also that it will be
2008
returned if
accident,
the.
Lord.
Yes.
Materials.
You address that by knowing well that the insurance policy had a stipulation that it will be effective after 2 days, after 2 days.
Before that point, I want to submit that on 6/5, the insurance authority has received the money.
That they are not denying.
That money. And for receipt of the same, my learned brother has stated that I have taken printout of the said particular document on 3:30. This doesn't mean that I have purchased the policy on at 3:30. Now, my lord, sections 64B, 64(5)B of Insurance Act. Section 64, Roman 5, Roman V, B.
Small b. Insurance Act.
Insurance Act.
What it says?
No risk to be assumed unless premium is received in advance.
No, that is not the issue.
Well, I'm
Here premium, they are not denying receipt of premium.
for moment they have received the my lord premium, the risk starts, my
Where it has been.
lord. First clause is not applicable to me, man. The second part is there, man. An explanation is there to clarify the clause 2, man.
Yes.
For the purposes of this section, in the case of risks for which premium can be ascertained in advance, the risks may be assumed not earlier than the date on which the premium has been paid in cash or by check to the insurer. Where the premium is tendered by postal money order or check sent by post, the risks may be assumed on the date on which the money order is booked or the check is posted, as the case may be. So, my lord, the risk of the insurer starts from the time when the money order has been posted or the so and so. In this regard, my lord, since already my lord, time has left, I want to refer one judgment on the Honorable Supreme Court.
No,
Should be-
this clause says 64 5B says that the risks cover would start only after, it will not start prior to payment of
Yes,
premium.
not prior to payment. I am not that. It should not be
Mm.
prior to receive of the
But
payment. But immediately on receipt of the payment, the risk starts, right?
that it does not say.
Explanation, my
The
lord.
explanation only to to explain that in case of postal deposit of checks,
Even on the moment when the money
the check
order
is
was
posted.
booked. Yes, sir. At the moment the money order is booked. Now, my lord, I have paid the premium in cash, my lord. They have received the amount and issued the issued the money receipt. And the moment he has received the cash, the premium in cash, the risk starts.
It does not say in all cases.
Now, my lord, in this regard, my lord, I would like to refer also the Dupartes case, my lord. Paragraph 3.7. This provision has been, my lord, referred to and accepted. Here in this case, my lord, loan was obtained, my lord. Thereafter, my lord, in relation to the loan, payment was made to the, my lord, authority, to the insurance authority, and thus 3.7, page 724, my lord. May I read, Lord? Para 3.7.
We'll continue tomorrow.
Bye.
Tomorrow. Because it may not be proper to rush,
Yes.
not first item of the day. At a particular time. How much time will you take? 5 minutes. In your second case, how much time will it take? So at 4 p.m.
As to tell, my lord,
At 4 p.m. as a fixed item.
all arguments will be public.
Mr. Goswami, at 4 p.m. tomorrow. 3:45.
3:45. Yes.
He's targeting a long,
I will not allow long now.
I will not.
he has a long submission in mind, Lordship.
No, no, ma'am. So already, my lord, my submission has been made by my learned brother.
Heard Mr. R. Goswami. This is the item number
15, ma'am.
15.
Okay, 15.
Record bill clock, sir. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. A. Lal, learned counsel for respondent. Respondent. We are hearing the second matter, item 17 now. Respondent. Also heard Mr. S.S. Vaikya. Yes, M.K. Sharma. Learned counsel for respondent number 2. Hearing remain inconclusive. Let this matter be listed tomorrow at 3:45 p.m. as part third matter, as a fixed item. Remaining matters left over.
Interim is to be continued
Alright.
in the year, in the item 38.
Wherever there is interim, it will continue.
But in item number 18, it's a part heard matter. If your lordship fix it on next week, Monday, Tuesday, lordship. The part heard matter already had it length.
No, let it. No fixed date was given. On last occasion, no fixed date was given. You pray for listing before registry. All leftover matter, pray for listing before registry. And no prayer for fixed dates.
Please, Your Lordship, item number 25 to be fixed on date 9 December.
No, you have not understood what I have said.
No fix.
Perhaps lordship, last date, the matter was fixed for today. My learned friend said he is also for the, one of the claimant.
Verify it. If it is so, mention tomorrow morning.